it stops, no one knows. We're going head into the unknown. Na, 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 na.
Hello, 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 everybody. Welcome back to Criminality. Or if this is your first time here, welcome to Criminality. Thank you guys for being here. I know it's been a few days. As many of you guys already know, and I told you guys last week, I am leaving out of state tomorrow. So it's just been with Father's Day weekend, and happy Father's Day to all of you dads or single moms that also have to be dads. So I am leaving tomorrow. So I've just been trying to get everything ready to go and make sure that, because it's just my daughter and I that are going, so making sure the boys are going to be okay here without the assistance of the female in the household. You girls know what I'm talking about. So it's just been super busy trying to keep up with the Karen Reed trial. Some Delphi documents obviously dropped today. That's what we're here to discuss. And so I've just been kind of running around like a chicken with my head cut off. I do my hope, and this is my hope, is to be able to do at least one Karen Reed live while I'm gone. So obviously she's competing, but she doesn't compete every day. So that's my hope, is to get at least one Karen Reed, a good solid few hour Karen Reed live in to recap the happenings of everything that's going on this week. I have so many things to say. I don't know if I'll be on my phone, so I won't be able to like screen share or anything like that, but I'm just going to chat with you guys about it regardless. So if somebody can't come up and help screen share, if there are any more documents that come out in Delphi, I will try to go live with that as well. Just no promises. But like I said, I don't want to get too far behind on the Karen Reed case and not be doing the recap. So I'm hoping to do at least one solid week 8. We should have the Commonwealth resting in the Karen Reed case by Friday, and the defense case starting. So we may be on verdict watch by mid to end of next week, which, thank God, I'm so over that trial. It's like pulling teeth at this point to even like listen to what they're saying. And I notice as I go back and like listen more, I'm like, oh, fuck, I missed that too. Because I'm just like, let's go. So let me say hi to everybody here, and I will get started on the new Delphi documents that dropped. So Teresa says, thank God I just can't stand listening to Lolly. I know, and then he's like said something important yesterday, and I was like, oh fuck, what did he say? It's like, let me rewind it, and then he'd actually said like 2 things, and I was like, I totally missed one of those. It's just, I don't know. I'm ready for it to be done. I am ready to move on. I have other things I want to do, other things I want to talk about. My gosh. I did tell you guys that we got the Madeline Soto documents, and there's no way. There's 900 pages. Even with all the redactions, though, there's still hundreds and hundreds of pages. I mean, it's incident reports, it's police reports, it's all of the things. Sleuthy Goosey, she's probably not here right now, but she was kind enough to help me organize them into a Google Drive because there's just so much. Oh, there she is right there. So thank you to Sleuthy Goosey for doing that. I also sent them to my friend ATS News, and I will make sure to put her link in here. She's going through the entire thing in parts. So I highly recommend, if you are paying attention to the Madeline Soto case, to please hang out with ATS News. She'll go through it with a fine-tooth comb and go over all the details. So I don't know if one of the wrenches in here can drop ATS's channel. I would really appreciate that. So she's going through all of the Madeline Soto file that we got. There's actually We got about 900 pages, even though a lot of it is. Francis, what's up with the name Whiskey Thoughts with Frankie P? Okay, I'm gonna have to try to remember that. You're playing tricks on me there, Francis. Trying to go through all those pages. Like I said, there's probably at least like 50, maybe even more of them that are fully redacted pages, but there's actually like 1,500 pages. They didn't release all of them yet. So there's probably more going to be coming. It's kind of crazy. So anyway, if you guys watch it over at my friend ATS, if that's a case that you are following, she's doing a great job going through the documents piece by piece. So, hi, Hammy. I'm 20-something girly on medical leave from grad school in Boston, battling through sickness. Aw, and your kindness and humor reminds me of home and growing up back in SoCal. Thank you for all you do. Aw, that's so sweet. Thank you. And I hope that you get better very, very quickly. SoCal. SoCal, baby. Hi, BH. What's up, Momo Shark? I make videos once a year. Good to know. Good to know. Okay, so this is ATS's channel. Thank you, Marshall, for dropping it. And hi, Marshall. And then I was talking to you, Teresa. And then hi, Mar. Hi, Anja. Odds in chat. Hope you are all well. Hey, Kel. What's up, Freeze Dry It? Hey, Rex. Nicole Bacon. From what I understand, there is another Soto drop of 900 plus pages, so it's up to 1,800. Oh, okay, I thought it was 15. Maybe you're right. That's even more. So they said that they will be sending more as they can, as it's approved. So, hi, Kyra. Hey, Jancy Scott. Even his own witness says kill me during his questioning. This was up for debate. Like, many people now think that it was Lolly that said it, but since we couldn't see him, we can't see if it was him or not. So that's actually like up for debate. My initial thought was it was the witness. You can see he kind of leans over, but I don't know if his mouth is moving or if he's just like closing his mouth from it being open. I don't know. Either way, somebody in the Karen Reed case is over it also. And if it is Lolly, that's even fucking funnier. Hi, Sunshine and Roses. What's up, Kathy? I hope you're doing well. Hi, Alicia. Trooper Paul. Oh, God. He was a disaster. I've never seen anything so bad. Never seen anything so bad at all. Hi, Artsy Fartsy. Hey, Susan. Yeah, but the real experts are coming soon. Yeah, I know. Hi, C-Dev. I'm over the prosecution, but can't wait for the defense. Well, they're saying they're going to be done in like 3 days. The defense is like, we need like 3 days. And I don't want to stay on the Karen Reed case for too long, but did you guys hear, did you guys watch the voir dire today? And Judge Bev was asking Jackson, like, are you going to need to call like Jen McCabe back? And he's like, we've done all the damage we need to do to Jen McCabe. I was like, oh shit. And she's like, I'm sorry, I didn't hear what you said. He's like, oh no, we've done the damage to Jen McCabe that we needed to do. I was like, wow, Jackson. Competition is the Olympics fever running high. Is everyone all inspired and excited at practice? Yeah, we had the final party. It's like the final practice, and then they have like a party. Was today, so we did that already. So you get some sun, get some big sun. I've been spending more time outside because it's summer and the kids are out. So, but I'm always kind of red anyway. I don't know. It's like a weird. Hey, quietly concerned. Hi, Tony. Nicole says, I can't get into Karen Reed. It's those damn Boston accents. Those damn Boston accents. Hi, Hootis. What's up, Just Deb? Hey, Jen. Hi, Dina. Hey, Laura. Hey, Elena. So I took a break from Discord for a couple months, logged back on today, and discovered the NOT server was gone. So I don't even know all the details to be able to explain this, Tony. I do know that it is all gone, and there was a split in the unraveling on the channel. So I think the girls are sticking with the R&M channel, and then I think Paul Tobar is going with the unraveling channel. But like I can't even get into the details of it because I really don't even understand them or know them, except for there's obviously some type of implosion, and that is the non-Discord is gone. What's up, Yankee Ghost? Hi, Fiend. Yorkie. What's up, DB? Hi, Mother of Dragons. The Royal Wheat. Even though you went back to the Royal Wheat, it's always the Royal Wheat. Hi, Unindicted. Hi, Kayla. Hi, Thierry. Hi, Ramblin'. Hey, Wayward. Snappy Dragons in the house. Hi, Sharon. All right, I think I got everybody up here. Hey, Chris. Hi, Donnie. Cleveland rocks. Oh, good thing I kept going. I would have missed Cleveland. Can't ever miss Cleveland, right? Hi, Patty. What's up, Rebecca? Crash of the party, Carrie. Do it. IVJBC. Just haven't seen you in a while. I know. That's like crazy. And I'll probably only be on like once in the next week, too. So behind on the Delphi case, but ready to listen. Well, not much is happening with Delphi, so you're lucky on that aspect. It's not back-to-back filings and crazy shit happening on the daily like it was for a hot minute there, so you're good. What's up, Lady D? I started a baby blanket for the new nephew. Did you really? So I got to see him for the first time finally on Father's Day, and he is so fucking cute. So cute. And he's so tiny, so tiny. Hey, what's up, Irish Jenny? Yeah, the unraveled kind of, but stick with the R&M. They'll put out the content there. Hi, this is Francis. He's a pain in my ass, but he's funny. Yeah, I can feel you. I see where you're coming from there, Jessica. I have one of those myself, though, so I get you. And welcome. It says, this high season in the beginning reminds me of the Magic Garden. The tone change when you read people's names cracks me up. I hope that's not bad. What's up, Judy? They'll be back. They're going to be on R&M, so just stick. That's what I said. Stay with R&M, and you'll get to see the girls. Hi, Tammy. Hi, sweet Melissa. I think you mean romper room with all the I see so and so and so and so, and I see so and so. Hi, Kay. All right. IFG. Okay. I think that. Did I say hi? I saw Judy up here. Did I say hi to Judy? Oh, I think I just read your comment, Judy. I don't think I actually said hi. There's an author with the same name as PW that has some weird book covers. Ooh, people say those are books he wrote. I was just kidding, but it was triggering, I guess. He did say something. I heard. Okay, so now let's move on to Delphi. And for anybody who hasn't seen it, on Sleuth Intuition, and one of the mods will hopefully drop that too. Patrick Westfall came back and did a Q&A, question and answer, and Sleuth actually did an open panel so people could come up and ask questions themselves. I unfortunately was at my in-laws and was not able to join, but I did catch the replay. I thought it was very interesting. When I have time, there's a couple things that my memory says from the first interview are different than the second interview, but I don't want to go too far into it until I can make sure that I'm right. Because obviously it's been a little while and there's a lot of stuff in my brain that cannot like override the old stuff. So I want to make sure that I'm right before I just start saying whatever the hell I want to say. What's up, Catastrophe? Hi, Four Pits. Hey, there's Arnhem right there. I need a magic. I need a magic mirror. Y'all are showing your age. All right, let's see. Yeah, I definitely lived the life of my age. So I didn't. There's nothing that I'm looking back on going, holy shit, I wish I would have done that. Well, maybe, but not really. Hi, Shaz. Mustang driver, Mustang driver. Oh, thank you, Mother of Dragons. Sweet. Some funds for the road. Okay. So, but I highly suggest going to watch the open panel with Patrick Westfall. Super cool that he opened the panel for people to come on. And then obviously, I mean, Patrick Westfall is a high interest in the case of Delphi since that Frank's memorandum came out. And I would say closer back to the beginning of the case, but not nearly as much as Brad Holder was. So I think I think it's definitely worth the listen. And then I will hopefully. So my plan is when I get back, I'm going to be doing some lives that may be outdated by that time, like outdated, like it's going to cover some older stuff because there's stuff with lists that I still want to cover that I haven't been able to. There's obviously the Madeline Soto stuff that I still want to be able to cover. I would like to do a panel on the Patrick Westfall interview. So some of the stuff might be outdated when I get back. but it's still stuff that I want to cover and talk about with you guys. So I'm just gonna do it anyway. It is what it is. I'll be in and out of chat cooking dinner. Is it Taco Tuesday? Aw, see, there's Francis. Aw, I love you. He's like, I'm sorry that I'm a pain in the ass all the time. Other than white, what is your favorite color? DB, that was freaking funny. Oh, so anyway, what made me start talking about the Patrick Westfall thing was that there was a question to Patrick about why he chose specific book covers for his books. And he's like, what are you talking about? He's like, I've never written a book. I don't have any books. So DB in chat is saying, apparently there is an author that is has the same name. And now I'm curious, like, what those book covers actually look like. Oh, Carrie, 3 months. Woo woo. And you gifted 5 memberships. Look at that. Sweet. So I do plan on posting some pics from the trip as members only pics, just so you guys can kind of see as we go. So if you guys are members, you can look forward to, I'm going to post some of the pictures as we're out and about. We're going to be visiting a couple different states. So should be fun. Okay. Now let's get into it. So the defense filed a motion today. It's not really a motion that they're really acting like they want anything to happen with. It was more for the record and any type of future courts that may end up having to look at this case. So all of us that keep going like, oh, the defense keeps filing motions literally for the appellate court. I mean, we know that they do. That's part of their job. They have to. And they have to secure the record to make sure that any other future court knows that. What's up, Untamable? You did, Francis. Look at you. It's okay, T. It's your channel. Maybe do a series of videos and not a live for older stuff. Either way, I'm here for it. I like to listen to things during the day while I'm working. Sweet. Yeah, we'll figure it out. We'll figure it all out. KK. Oh, thank you, Ashley. It is. It's fine. It's finally hitting the summertime. So we know that we had the hearing, and Baldwin was like, "Hey, Judge Gull, I have this motion to make you go away, and we want you to recuse yourself and leave this case." And he's like, "Do you want it now?" And she's like, "No. I'll just look at it when it's filed." And then he ends up filing, and it ends up being like, I think like 15 or 16 more pages than it even was in the courtroom. We read through that. And then she comes back and she says, they ask for conclusions of law for her to write that in her order. Well, so she pops back in her order and she's like, I'm not going anywhere. Too bad, Baldwin and Rosie. You guys are just going to have to deal with it. And I'm not going to tell you why, but I will go over a couple of the points that you guys have said that I did wrong and essentially tell you how stupid you all are. Well, they're coming back today saying, well, thank you for telling us these specific things, because now there's even a bigger problem and we have a conflict and you need to recognize the conflict. Otherwise, we're writing this for any future court to recognize this conflict, because either you lied or you're telling us in your order that law enforcement lied. So either way, this is going to be a problem. And now I have it. Thank you, Sleuthy, though. She's like, either way, it's going to be a problem. Or that's what they're telling her. Like, you need to figure it out because you're either a liar or they're lying. And that's not good for either of you. So that's what they're writing to her today. And then they obviously have some exhibits that they give her. So I have not read this entire thing yet. I skimmed it. So some of it might be kind of a raw reaction. I do have up the motion to disqualify in case we need to look back at that. And I have the order that she issued back on May 31st. Now that the wife is here, can we air our dirty laundry? All right, I'll just have to create a stream and you guys just come up and she can tell. How about she just comes up and she can tell us all the things about you? I think that might be better. That might be more fun. I think I'd enjoy that, actually. But thank you for the super sticker or super chat. All right, let's see. It's suspiciously well written. So Baldwin didn't write it. Probably Jennifer wrote it. All right, let's go. Depends on who reads on what you take from it. I enjoy T's readings. Thanks for Pitbulls. All right, I'm gonna wet the whistle. Francis, you in trouble now. You in trouble now. The trial dates for October show canceled. Yes, so it's been like that for a while because the trial was moved to October when it was for when Labrado and Scremin took over. So it was originally moved to October, and then it was canceled and moved to May, and now it's moved back to October. R&M, I wrote it. I heard all the YouTubers on the defense team wrote it. Well, I mean, people not even YouTubers supposedly wrote the Franks memo, right? Okay, so here we go. Make sure you guys can see this, and we will take a look. So it comes down the accused Richard Allen Byron through counsel and files his response to this court's May 31st, 2024 order or judgment of the court and notice of conflict. In support of said motion, Mr. Allen states the following. On May 31st of 2024, this court issued its order or judgment of the court concerning the defense's request to have Judge Galt disqualified. Contained in said order were several errors. The defense is filing this motion to preserve those errors for future courts if needed, and to notify this court that due to new information learned in her order, a conflict has been revealed, which has caused Judge Galt to become a witness. As soon as I read it, I was like, can I get a witness? Hi, Crazy Aunt Liz. Mandy. Mandy says, yeah, I mean, we all pretty smart. I can tell you right now, I could do a better accident reconstruction than that guy that did it in the Reed case yesterday. Yesterday. And I don't know shit about cars or physics. Hi, Yellow. Let's just let Annie Bev do it. At this point, I think I prefer for Bev to be the one that did it. Hey, Ems. Oh, yeah, he writes them all. So the defense files this response and notice for purposes of maintaining a record and does not wish for this pleading to delay future hearings from taking place, particularly hearings related to the defense's request to transfer Richard Allen out of the Department of Corrections, which is the most urgent of the pending matters that need litigated. Also, the defense's response is intended to provide correct information to Judge Galt as she continues to self-evaluate her obligation to recuse herself from the case should she believe that bias or the appearance of bias exists. I want to touch on this really quick because what I have heard a lot lately is people asking, if Richard Allen is in such a bad way at the Department of Corrections, why isn't anything being done about it? And I just, for anybody who does have that question, I would say they have been. They're going through the right proper procedures to be able to have him moved. And I do not believe that the sense of urgency on having him moved is necessarily the same as it was when he was in Westfall. When he was in Westfall, there was a lot of things that we've now read through defense filings and just through the actual transcripts from the court on what was happening in Westfall versus what's happening in Wabash. Obviously, he's still a pretrial detainee, which is not common that they're held in the Department of Corrections, and it would be in his best interest to be in the in a jail. Tippecanoe jail, I think, is what they end up actually asking for in this filing. But I want to make it clear, I don't think that the fight is. I don't think the defense attorneys need to be on the front line for the fight of moving him from the DOC as much as they were when he was at Westfall. I think things have absolutely changed in his health and his mental well-being. Now, does that mean that he should be in the Department of Corrections? No, it doesn't. So I kind of wanted to throw that out there. I think that people are are thinking that the claims about Wabash are the same about the claims that were about Westville, and they're not. They're very different. What they're claiming was happening to Richard Allen is very different at both facilities, and the reason for him being moved or wanting him to be moved. So I just wanted to put that out there in case anybody here was trying to figure out, why they weren't fighting as hard as it seemed like they were fighting before. That's my opinion. So you guys can take it for what you want. And hi to everybody that's just popped in. I see a whole bunch of you guys have just joined. So hello. So footnote, a judge's obligation not to hear or decide matters in which disqualification is required applies regardless of whether a motion to disqualify is actually filed. So Judge Gall failed to inform the defense that Carroll County Sheriff's Office fabricated facts in a report filed in her court. In his motion to disqualify, Mr. Allen noted that according to June 14th, 2023 report filed by the Carroll County Sheriff's Office hereinafter the CCSO, Judge Gall advised the CCSO that it could ignore a valid defense subpoena for Westfall Correctional Facility inmate Robert Baston and refused to transport him to the June 15th, 2023 hearing on Mr. Allen's emergency motion to modify the safekeeping order. Now, we've got those transcripts. We've read through them. If you guys missed it, make sure you guys go back and listen to that if you want what actually happened in the court that day. The defense further alleged in its motion to disqualify that because of Judge Gall's actions, the defense was without a key witness for the hearing. So this is going to be this is the whole thing where I was saying she's either going to have to say she's lying or she's going to have to admit that law enforcement's lying. It's because there's now statements from both that do not match. So who's telling the truth? So it was anticipated that at the June 15th, 2023 hearing, Mr. Baston would testify as to the harsh and abusive and unconstitutional treatment of Richard Allen at Westville's correctional facility. The failure of the CCSO to transport the witness from Westville left Mr. Allen without crucial evidence for the hearing, thereby subverting justice for him. However, in her May 31st, 2024 order, Judge Gall claims that she never advised the CCSO to ignore the subpoena and leave Baston behind. Judge Gall's claim contradicts the CCSO report that this court received on June 20th. The June 14th, 2023 report, which was ordered by the court, stated the following. On June 14th of 2023, I, Special Deputy, which is Brian Wysocki, while on duty, was conducting transport from Westville Correctional Facility to the Carroll County Jail. Upon my arrival, I was escorted to Baston, Robert segregation unit to conduct the pickup. After waiting, a corrections officer approached and told me that Baston is refusing to come out of his cell and told the corrections officers, "Fuck you, you can't make me go." The corrections officer told me they will do a cell extraction to get him to my transport vehicle. I told the corrections officer to stand by, let me make a few phone calls. I was escorted back to the main gate where I was greeted by John Gallipo. That's the warden, by the way. I called Carroll County Jail Commander Lori Sustarsik, who I explained the situation to. She then made a phone call to Chief Deputy Tobe Lesenby, who contacted Judge Francis Gall's office to inform them of the situation. Jessica, I almost wanted to say that. Judge Gall's office advised to leave Baston there if he did not want to attend the court hearing that is scheduled for 6:15. Judge Gall's office advised them, hey, don't worry about it. I then spoke with Warden Gallipo and asked if he could provide me with a letter stating that Baston refused to come out of his cell, that he did not want to go. The warden agreed that he would. He later advised he would bring me the letter on 6/15/23 to Carroll County Courthouse so I could attach it to his report. Nothing further at this time. The report was approved by Tobe Lesenby, who is a key witness in this case. Juxtaposed to the CCSO report as Judge Gull's May 31st, 2024 order, in which she stated the decision by the deputy to leave without the witness was his and was not directed by the court. The first time that Richard Allen's counsel learned of these contradictory stories was in Judge Gull's May 31st, 2024 order of judgment of the court. So let's go over here. I think there's only like one paragraph where she actually talks about this, where she's like, I will address each of the defendant's allegations in this order. She says the defendant claims the court directed the Carroll County's sheriff to ignore a subpoena. The court directed an email to counsel on June 14th, 2023 regarding the witness refusing to cooperate with the service of the subpoena and demonstrating a willingness to fight the deputy attempting service. The court requested a report of the witness's refusal to cooperate and be transported for the scheduled hearing and forwarded that report to counsel when it was received. The decision by the deputy to leave without the witness was his and was not directed by the court. So somebody ain't telling the truth. So Judge Gull has possessed this report since June 20th of 2023. Upon receiving this report nearly a year ago, Judge Gull never notified Mr. Allen's attorneys of the misrepresentation contained in the report as it related to her purported involvement in the failure to transport Mr. Baston to the hearing. Essentially what they're saying here is, hey, you had this, you're the one who sent this report, which here's the copy of, here's what it says, the copy and paste. You knew that this, whatever his name is up here, Deputy Brian Wasaki said that Judge Gull's office advised to leave Baston there if he did not want to attend the court. And yet, for a year, you never bothered to correct the record that you actually didn't have anything to do with it. So you knew for a year that law enforcement was lying to all the parties involved and you didn't tell anybody? Or is it that you're lying right now? That's essentially what they're saying. And I mean, I don't know how all the very pro Richard Allen guilty people, I think this is just going to be like a swept under the rug, like who cares? This is an attempt by the defense to discredit Judge Gull. Well, no, this is Judge Gull actually discrediting law enforcement or lying. So they didn't have to do anything to put this together. So I just can see it's going to be like a, not a big deal, because nothing, it's never a big deal if it's something that they do wrong. Or it's this defense team, bunch of jokes. And here they are, like, writing it out, like, no, here, you lie, you lie, you lie. It's already happening. Oh, Jesus. I haven't been on. I haven't been on today. So I watched the Karen Reed situation, and that's my YouTube for the day. Hi, Bob. So I don't even know. So did somebody say somebody called it a ding dong filing? Ding dong podcasters, ding and dong. Are the feds looking into Delphi like Massachusetts? I don't think so, but holy shit, they should be. I mean, they really should. I don't know how they even got them to do what they did in Massachusetts, or what the situation was if they were already looking into something, but no, they're not. So it's going to be interesting because, like I said, it's either she's lying or she's calling them liars. And if she's calling them liars, then she's known for a year that they lied and she didn't do anything about it to correct that, or to correct that information. And secondary, they've talked about this in multiple filings that we've gone over. The defense has stated repeatedly about the court allowing Baston to not testify, and she's never corrected it. She's never corrected it on any type of filing before at all, until that order in May 31st, 2024. It's an atmosphere dong. Yeah. Rambling nonsense. That's funny because I know a podcast that I would call that. I'll never misconduct. I'll never misconduct when the state does it. It's never misconduct when the state does it. No, it's always like they had no choice because this stupid defense team putting all this together, doing what they've done because of the Franks memo. It's always because of the Franks memo. There's allegedly a federal civil rights investigation going on in Massachusetts due to a big court case in the Ninth Circuit. Ooh. Hey, Stephen. I really don't think this case is as fucked up as the Reed case. I don't know. They're freaking close, Scarlett. They're freaking close. Ding dong should be in every filing. Francis, you gonna get yourself in trouble? Probably at sidebar. At sidebar, she's probably like, come on, ding dong. We don't need to know about your bathroom breaks. It's like, it'll just take me a minute to go to the restroom, Judge. It's like, that's not what I'm talking about, silly goose. The cases are just so different. I don't think that comparing them is really fair. I mean, what your commonality is incompetent law enforcement trying to solve a case, but I agree with you. I think that it's very different. Bang, bang. It's a crazy sidebar. But anyway, I love Bob and Allie too. They are the best, the bestest. No, no, boss. I don't even think I'm doing it right, Nicole. I don't think I'm even doing it right. Okay, so let's see, where were we at? Upon receiving this report nearly a year ago, Judge Gold never notified Mr. Allen's attorneys of the misrepresentation contained in the report as it related to her, I think I read this one, her purported involvement in the failure to transport Mr. Baston to the hearing. At the very moment of learning that the CCSO filed a report with fabricated facts concerning Judge Gull, she should have immediately alerted Mr. Allen's attorneys of the misrepresentation contained in the report. Further, upon Judge Gull learning of the misrepresentation contained in the report, which undermined the evidence Mr. Allen was able to present, Judge Gull never reset the hearing so Mr. Allen could present the very evidence Judge Gull said was lacking when she denied Mr. Allen's emergency motion to vacate the safekeeping order. Additionally, as this court is aware, Mr. Allen has filed 4 Franks motions indicating that law enforcement has acted intentionally or in bad faith. Also, as this court is aware, Mr. Allen has filed 2 separate motions to dismiss based on law enforcement's destruction of evidence. One of those motions was heard on March 18th, with the court denying said motion on April 2nd, 2024. We're still waiting on the second one. One of the last things that we actually went over was Nick's response to that second motion to dismiss. So she hasn't made any determinations on that. She's got a lot of outstanding shit, but and we still, even though she has now May 31st done the order where she's already denied the defense's motion to recuse her. She has not set the hearings. She has not reset the hearings that were actually scheduled for May 21st to the 23rd. Those aren't even, she's not put those back on at all yet. Is she going to wait for somebody to ask for them? I don't know. Okay, she said that she had to approve the motion for the continuance based on the motion to disqualify, but then she denied the motion to disqualify. So I don't know why we don't have anything. We don't have anything to show what she's done. So we're probably going to get close to October, and we'll probably have a hearing October 1st, and everything's going to be a fucking mess, and nobody's going to know what's happening. That's my prediction. We won't see any hearings all summer. Why isn't there anything on the fucking books yet? What's up, Dan? This is another serious concern. Mustang driver says this is another serious concern relating to her appearance of bias. In our jurisdiction, if a motion to recuse a judge for cause is filed, the motion must be heard by another judge. It's crazy. A lot of places have it where the judge is the first one that makes the decision on whether they can. It's like they're trusted to the point where they should know whether they have a bias or not, or they know if they have a conflict, obviously. So they should be able to make the determination. It's like they have like that trusted judgment, so to speak. All right, let me see. So we've got the 4 franks, 2 motions to dismiss. To prevail on a motion to dismiss as it relates to the destruction of potentially useful evidence, the motion to dismiss requires the defense to prove that law enforcement acted in bad faith. Now, if she's saying that they were lying, this is another opportunity to show that that everything they're doing is in bad faith. At the March 18, 2024 hearing, defense counsel was attempting to provide evidence to the court that law enforcement has acted in bad faith over the course of this case. At that time, this court was aware that law enforcement had fabricated facts. Ooh, this is a good one. Had fabricated facts contained in the June 14, 2023 report, thereby acting in bad faith. Yet this court never alerted the defense, and therefore law enforcement's bad faith was not made part of the record. So like here, yeah, on March 18th, we're here trying to tell you that they lie, and they keep lying, and you're like, nope, 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 they're honest folk. And yet you knew they lied over a year ago. I agree with you, Patty. It's kind of just like, no, like once they're convinced that that's the person, it's like their civil rights are just gone. Yeah, I've only skimmed this so far, Sleuthy. I did not read it verbatim. I just kind of looked over some of the main points. So yeah, some of it's raw, so to speak. Hey, Ems. It's like asking Proctor if he was biased towards the Alberts and expect him to say the truth. Yeah, he's like, no, I'm not. I was not biased. I didn't even know them. No, I brought out some weird English accent. I don't know where the fuck that came from. Sorry. And says, I've seen Gull throw the COC under the bus, so this doesn't surprise me. Obviously, Ellie is not trustworthy in that area. However, I would bet money that she is the liar. Well, what it's going to come down to is something about the office. That's where I'm at. And because they're saying like, oh, that Tobe contacted the office, and so she's going to be like, it was the clerk. It was her fault. She did it. I have no idea. I'm just all over the place because I haven't been on here for a while, so I'm feeling all the things. And it's just coming out in the accents. I don't even know what the hell I'm doing. The YSL trial is also freaking crazy, especially the witness Woody. Totally worth watching the recaps. I haven't, and I should. I just had time is not on my side. Okay, so we just did that one. Even if this court would still claim that such a fabrication in a report would not have changed her ruling on the motion to dismiss, the fact is that the defense was not able to include that information on the record for the Court of Appeals, should it be necessary. Bob, you probably are. You probably are. And this makes me think, somebody had mentioned Idaho, and Bob, I don't know if you listen to any of the Idaho stuff, but every time that we talk about Judge, he literally reminds me of the human version of your family hugs. Like he's like, oh, family hug, but like that's just like his absolute personality. He's like, you guys, let's just be friends and work it out together. I don't know, it made me laugh. Additionally, had Judge Gull alerted Mr. Allen's attorneys of Carroll County Sheriff's fabricated statement in that report, the defense could have used that fabricated statement when pursuing their Franks motions and motions to dismiss in order to provide additional evidence of the intentionality and bad faith on the part of the CCSO. Furthermore, by failing to provide this information to Mr. Allen's attorneys, Judge Gull prevented the defense from investigating this fabricated story, including through depositions. Judge Gull should have alerted Mr. Allen's attorneys of CCSO's fabricated facts written in their police report well before the March 18, 2024 motion to dismiss, and her failure to do so provides a rational inference of bias. Well, no, yeah, because she didn't care. She doesn't care that they're lying. She doesn't care. It's not a big deal to her. So, given that the judge, Judge Gull is now a witness in this matter as to Tobe Lesenby's credibility. So they want to use Judge Gull to impeach Tobe Lesenby. Could you imagine that they called Judge Gull to the stand? Given that Judge Gull is the only individual who knows that she did not direct the CCSO office to ignore the subpoena and leave Mr. Baston at Westfall, despite the contrary assertions in the CCSO report, she has become a witness to Tobe Lesenby's truthfulness and to the fact that the information contained in CCSO's reports are false. The credibility of a witness is always an issue for the jury. If Judge Gull's story is correct, then she had a ringside seat to the intentional behavior of the CCSO and or the bad faith of the CCSO in that it, one, intentionally ignored a valid defense subpoena for a defense witness, and then two, fabricated a story in a police report claiming that the sitting judge on the case authorized the CCSO to ignore the valid defense subpoena. In this scenario, Judge Gull is a witness. At future hearings and at trial, the defense should have the ability to cross-examine Tobe Lesenby on these contradictory stories with questions similar to the following. Mr. Lesenby, the defense attempted to bring a witness named Robert Baston to testify at a hearing concerning his observation of guards abusing Richard Allen in a variety of ways at Westfall. But your office ignored a valid subpoena to bring that witness to a hearing. Isn't that right, sir? The attorney would say, you did not want the judge to hear the testimony of that witness because it would support the defense's contention that Richard Allen was being abused and should be moved to the Cass County Jail closer to both his family and his attorneys away from the abuse. Isn't that right, Mr. Lesenby? The attorney would say, you wanted Richard Allen to remain in the Westville prison so that he would continue to be housed far from his attorneys and his family while emotionally vulnerable to the abuse he was suffering at Westville. Isn't that right, sir? Or we would say, worse yet, Mr. Lesenby, you then lied in a report claiming that Judge Gull advised you that it was okay to leave Baston behind. You lied about that in your report, didn't you, Mr. Lesenby? Or we would say, Judge Gull never told you that it was okay to ignore a valid defense subpoena? Did she, Mr. Lesenby? Or I would say, I'm handing you Exhibit 85, which is the June 14th, 2023 report from the CCSA, in which you claim that Gull gave the directive allowing you to ignore the subpoena. Because the defense is claiming that law enforcement has acted in bad faith, and bad faith is an important component in its motions to dismiss as well as the 4 Franks notices, it must be able to call Judge Gull to the stand to testify concerning the false statements contained in the CCSO's June 14, 2023 report. Judge Gull's testimony is especially vital concerning the defense motions to modify the safekeeping order, as well as their Franks motions and the motions to dismiss. Calling Judge Gull to the stand to testify as to the fabricated facts contained in this report is especially important when the very witness who is the subject of this report, Robert Baston, would have testified about Richard Allen's treatment at Westville, which directly then led to the deterioration of his mental state and false statements concerning his involvement in the crime. The defense plans on issuing subpoenas and calling Judge Gull to the stand at future hearings and at trial to testify that she never directed the CCSO to ignore a valid subpoena and also never advised the CCSO to leave Robert Baston behind if he, Baston, did not want to attend the June 15, 2024 hearing. Judge Gull should recuse herself from this matter as she is now a witness in the proceedings. Dang. All right, let's see what you guys have to say about this part before we go to the next one. I mean, how she's not going to be called as a witness. She's not gonna be like, all right, fine, you guys win. I'm gonna step down, and you guys can go ahead and call me as a witness. Like, that's obviously not what's happening here. But I mean, they're not wrong. But my opinion is that she's gonna blame it on somebody else. She's gonna be like, no, they called the office. They called the office, and somebody told them that it wasn't me. It wasn't me. She's gonna pull a good old "it wasn't me." I was so glad to see they actually said they would call her too, not just that she would be potentially considered a witness. Oh, like when they did with like Nick. I hope Judge Gold will prosecute me to the fullest. This is so dumb. Oh, Scarlett, love your channel, T. Even if I disagree with you, sometimes you're one of my favorites. Well, thank you, because that's like the whole thing. It's like I don't pick people I like based on their opinion on a case, because like we have so many cases that we cover, and we could agree on like 50 of them and disagree on one, and now all of a sudden we can't be friends. It's like, no, that's not how it goes. Like, it's good. We don't always have to agree on everything. We just need to be able to talk about it, and then know that at the end of the day, we like each other because we like our personalities and each other as people, not because of our opinions on a case. Because I'll tell you, if you only like somebody based on their opinion on a case, your friendship isn't going to last past that case anyway. So, just saying. Francis, yeah, I think I would say so. And I that's so weird. That's so weird. The Shaming of Jay is doing a live shortly about the Unhinged list press conference. I can't wait. Love Jay. Love Jay. Still need to freaking know if Jay ever read the damn Canton Facebook post. I even emailed it to him. The tribe has spoken. Baldwin has to write what a hearing might sound like because we never have it. That is so true. He's like, this is what I would say if you let me in your courtroom. But since you don't ever want to let me in your courtroom, I can't actually say anything. Is anyone upset that Hennessy hasn't said thank you to everyone who donated to them for RA's experts? I listened a little to cry about the other night. Is anyone upset that Hennessy hasn't said thank you to everyone who donated? No, I am not upset. I don't think Hennessy didn't create the fundraiser himself. He had help from a couple people on YouTube, and one of the major people on YouTube, unfortunately, is not on YouTube currently. And so she can't say thank you. She has some other things going on in life. And it was set up with him being the primary attorney because the actual attorneys on the case couldn't be a part of it. I wouldn't donate for a thank you anyway, but that's me. No, and I don't care that he didn't say thank you. I think that you donate to something like that, I think that you have to know and have faith in that it's going where they say it's going, or you have to be comfortable with not knowing where the hell it's going to go. You can't expect receipts on every single thing like that. Like, I don't, the commercials where they give you like the really sad song, and then it's like they show you all the really sad puppies and cats and all the people and across the seas that are starving, and they ask you to donate like $1, and you donate like $1 a month to save a child or to save an animal. I don't typically ever get a thank you. Just saying. I don't know. Like, that's why I don't. To me, it doesn't matter whether he said thank you, like, or not. It wasn't. He was a point of contact, so that's where I'm at with it. The heart wants what the heart wants, Francis. It is. It's gonna do. It's gonna do whatever it's gonna do. Sudie says that's like giving food to a homeless person and filming it for your YouTube channel. You're doing it for attention and praise. If you're gonna do it, just fucking do it. Right? Just fucking do it already. Just do it. Well, because if he threw a pizza party, Phoenix, then people would complain that the money was spent on pizza. Luke says Ron Logan played a part in this disaster. Which Ron Logan? The real one or the YouTube one? Or the one that says he's not Ron Logan? Oh, shit. Okay, will you throw this in the description box if it's worth it? Hold on. Hi, Greenlee. What is it? Did I miss your comment that you want me to throw something in there? Tell me what it is. They'd complain that it wasn't burgers. And then would we all have to go live and like say thank you for the pizza? Oh, it's callback to a stray cat joke? Oh, I missed it. We all asked for a way to press a button to donate money for an experts fund, and we got one. True. Oh, yeah, I can put this in there. I can put this in the description. Sleuthy has it, too. She can drop it. She's a wrench, so she can drop it, and you guys can just grab it from here, and I can add it, too. Jen P, what's up? Oh, my God, I didn't realize you were live. They couldn't host it. Let's take bets on Hennessy's preferred pizza. You think he's a pepperoni guy? Oh, man, I think he's totally a pineapple dude. What the fuck? Good thing that nobody asked you to. Have a good day. Hold, please. Silly gooses. Silly rabbit, your tricks are for kids. I don't like pineapple on pizza at all. I don't like warm pineapple. It doesn't belong on pizza. See, Sleuthy, you know what I'm saying. It does not belong on pizza at all. It doesn't belong warm. It's supposed to be cold. We all end up in purgatory. It's a never-ending hamster wheel of thank yous. Well, thank you for coming on and saying thank you. No, but thank you for coming on and saying thank you. Thank you for thanking me. All right, hold on. Let's do this too. While we're in here. There you go. That's because you guys are the bestest. You love pineapple? Oh, man, yuck. Oh, I should do a poll. She didn't create any of those pictures. She didn't collect any of those pictures. John Ray didn't find that information. Someone sent it to him, and he just went with it. Yes, I know. I know you're probably talking to the other Teresa. But so I dropped 5 memberships for you guys. Because pizza doesn't belong on pizza? Pizza doesn't belong on pizza. Now that I'll disagree with. I'll put a piece of pizza on top of another piece of pizza any day. All right. So she can't even type. It's so disgusting. Judge Gull's failure to admonish the CCSO may cause law enforcement to believe that they can create fabricated stories in this case with no consequences. Despite having the CCSO report since June 20th of 2023, to this day, Judge Gull has failed to admonish the CCSO for filing a report that contains such a flagrant falsehood and which is arguably an attempt to cover up their illegal actions and ignoring a valid defense subpoena. Judge Gull's failure to address that fabrication in any fashion whatsoever provides a basis for state's witnesses to believe that they can freely fabricate stories which subvert justice for Richard Allen without consequence. This provides a rational inference of bias. I would like to ask you guys, do you guys think that the CCSO lied, or do you think that Judge Gull is saying, is she passing the buck here? I'd like to know what you guys think about that, because for me, I don't think anybody called out the CCSO lying, because I don't think the CCSO ever lied. Yeah, passing. I think Gull lied in this instance. Yeah, I think, or she's just can't. Her memory is. The CCO has lied plenty of other times. I know, but why is this Brian Wasaki guy gonna just be like, "Oh no, this is what I was told"? Or do you think that like Lesenby was lying to the Wasaki guy that he talked to Judge Gull? I mean, I don't know. Brian Wasaki, dude, doesn't seem like he's just gonna come out of nowhere and just start lying about Baston. He's like, "Yeah, I don't really want to fucking take this guy, so I'm just gonna say that the fucking judge said I didn't have to." That seems kind of crazy. You know what I mean? Yeah, I think for this circumstance, I just think that she's passing the buck, and she's gonna try to say that it was somebody else. I bet she's gonna. I think she's gonna blame somebody in the office. Yeah, I think she was like, I don't care if the guy comes. If he doesn't want to come, don't make him come. Ew, whoa, that's a little too much. Too much there. Judge Gull continues to errantly accuse the defense of improperly filing ex parte documents. Ooh, this is a good one. Gilletta, I thought you were already a member. Maybe you're just coming back. We just call him silly. Lesenby isn't Liggett. Lesenby is a complicit, spineless nerd, but he, in my opinion, wouldn't lie outright. Well, it's weird though that he's saying like he contacted Judge Gull's office and that was the response he got. But when he was talking to Fortson, he was like, I didn't know if I could just call her directly. I didn't know if I should just like call her and say, hey. So I don't know. That's weird. It's a weird thing. In its May 31st, 2024 order, this court continued to claim that the defense is to blame for ex parte pleadings that were accessible to the prosecution. Oh, this is the one where she says, I sent them. Hold on. Let me see if I can grab it real quick. It's in here. Here. So this is on her order. So defendant blames the court for ex parte pleadings which were inadvertently directed to the prosecutor. The defense staff filed pleadings and marked them as quote-unquote confidential, apparently unaware that the confidential marking makes them available to the state but not the public. Counsel staff contacted this court staff and were advised that the statewide Odyssey case management system, not DocsPop as alleged in the pleading, has a distinct process for filing pleadings ex parte as opposed to confidential. The court did email defense counsel a tutorial paper authored by JTAC explaining the process. Since that communication, defense counsels had no issues. They've had no issues. They've had no issues since then. Why the fuck you lying? Why you always lying? So that's she's like, I sent them on the like how to do it, all the steps on how to do it. So on March 7th, attorney Rosie alerted Judge Gull about his grave concerns surrounding McClellan receiving the ex parte documents. It took Judge Gull 13 days to respond to this urgent matter. In her March, she might have been on vacation. In her March 20th, 2024 emailed response, Judge Gull wrote to the defense counsel, I would encourage you to educate your staff on how to properly file pleadings. Attached is a printout from the DocsPop filing process of the February 26, 2024 ex parte document that court staff mishandled, causing accessibility of the document to the prosecutor. All right, Exhibit A. I would like to offer Exhibit A into evidence. If I can get it to load, Your Honor. Why aren't you loading? There we go. So here is filing ex parte motion. The fucking title has the name in it. Verified ex parte motion for hearing on funding for expert services. Motion filed, accepted. Motion PDF. Here's all the things, all filed confidential. Okay. Proposed order, confidential. Proposed ex parte order on funding for expert services. Proposed order filed, confidential. Okay. So these are like the blank ones. Sometimes we see these. It's like, here's we're going to go ahead and fill it. We're going to go ahead and write it out for you. So all you have to do is sign it, Judge. Like they actually put all the, all the wording together for her. So we've seen that a couple times from attorneys all over. Verified ex parte motion for hearing on funding for experts. Here's your service contact. And then the email log. Okay, so here's this confidential, but she's trying to say it's not through DocsPop, but he's back over here saying it is through DocsPop. Let me keep reading because you know how that goes. I always end up doing that. Adds pineapple to the auto ban function for YouTube. Oh, shit. Yeah, Nick can't read, apparently, even though it literally said ex parte. He's like, oh, I think that means me. I think I'm the party that's supposed to read it. Okay, it should be noted that upon receiving this on February 26, 2024 pleading, court staff would see in bold font and capital letters at the top of the pleading the following: ex parte pleading to be placed under seal, which should have easily alerted court staff of the ex parte nature of the document, causing them to follow the proper procedures in processing an ex parte pleading. The staff for the defense filed the ex parte documents correctly. The DocsPop printout shows the only service contacts listed on this ex parte filing were Brad Rosie and Andrew Baldwin, not Nicholas McClellan, James Luttrell, or Stacy Diener. Furthermore, the printout shows that all documents were marked as confidential. In her May 31st, 2024 order, Judge Gull seems to believe that the parties can only file ex parte documents through the Odyssey platform. So I am by no means, I do not understand all the filing parts of how this works. I do know that there are multiple places where the lawyers have said that they can go and put the documents in or download the documents from. So this is, my knowledge of this is literally through the attorneys that have access to this and what they've said happened. And obviously from the court doc, same as you guys. So if so, she is incorrect. Parties may also file ex parte documents through the DocsPop platform, which is the platform defense staff utilized when they correctly filed the February 26, 2024 ex parte document in this case. Over the course of this case, defense staff used both Odyssey and DocsPop platforms when e-filing ex parte documents. It is telling that the tutorial, the quote-unquote tutorial, Judge Gull sent to the defense details how court staffs should process ex parte documents they receive in the Odyssey platform, not the DocsPop platform. Okay, so she's like, this is what you're supposed to do, and yet she sends them a tutorial, but it's actually what her staff is supposed to do when something is filed in the Odyssey platform and not the DocsPop platform, where she says they were incorrect, that it was they're actually talking about the wrong platform. Oh, Jesus criminy. Replaces the word with Dropbox. Odie doty. It means a delicious cake in my book. But yeah, I don't even know where we're at. I don't even know where you guys went to with them. We've got swinger talk, pineapples. Pineapple on pizza is apparently just as polarizing as politics. She would send that. That's insane. She's like, here, you guys should educate yourselves on a system that you're not even talking about. How do we feel about candy corn? Oh, gosh, don't get people started. Or Peeps. Oh, Peeps are gross. All right, see, now I'm starting to, I'm going to fall into the trap. Staying away from the trap. Hi, Dean. Okay. There is nothing else further that the defense can do to prevent these documents from being made public or misdirected to the prosecution. After the defense correctly files the ex parte document, the defense must then trust that the court staff has been properly trained on how to navigate an ex parte filing, whether it is filed using the Odyssey or the DocsPop platforms. That's essentially what like Osbrook and Kara Winnicke said was like, even though they were technically on the case as for limited purposes at that time, they could not access it. So it wasn't just any attorney associated with the case at the time. Which is why the defense thought that somebody in the staff actually like purposely gave Nick McClelland this filing. In this case, after the defense correctly filed the ex parte motion, somehow court staff erred in how it processed the document into the system, causing prosecutor McClelland to have access to the ex parte document. In her May 31st, 2024 order, Judge Gold detailed how she sent the defense a quote tutorial paper authored by JTAC explaining the process, end quote. The court implied in said order that she sent the tutorial to the defense in order to assist the defense in learning the proper process of how to file an ex parte motion. Judge Gull's presumption that this tutorial assisted the defense is inaccurate for 3 reasons. The defense was not errantly filing ex parte documents. 2, the tutorial the judge sent to the defense had nothing to do with assisting practicing lawyers on how to file ex parte documents. And 3, the defense continued to file ex parte documents in the exact same manner it had been filing before Judge Gull ever sent the tutorial to the defense, and there were no issues. Let's go to footnote 3 real quick. In her May 31st, 2024 order, judge referring to the email in which she provided the tutorial stated, since that communication, defenses had no issues with their staff properly filing ex parte pleadings. This court attempted to give credit to the JTAC tutorial for her claim that no ex parte issues occurred after she sent the tutorial to the defense. However, this is simply not true, as that tutorial provided no guidance for practicing lawyers, and as discussed above, the defense was already correctly filing the ex parte documents. It seems likely that the actual reason for no further ex parte issues was that the court staff actually learned the proper manner in which to process ex parte documents. I could not imagine that anybody wants to work at this with this judge in her courtroom at all anymore. Everything ends up being their fault. It's always their fault. Everything that happens is their fault. Even when we went to the Supreme Court, she still threw him under the bus. She was like, "Nuh-uh, that's not me. I don't know what's wrong with them not being able to put the documents out correctly. I created an entire website." It just freaking cracks me up. Oh, shit. Okay, hold on. Let's go back up. The tutorial Judge Gull emailed to counsel is actually intended to assist court staff and clerks on how to properly handle ex parte documents after the private practitioner has filed the ex parte document. In other words, the document that Judge Gull refers to in her orders does not in any way assist the practicing lawyer in filing ex parte documents, as it is a tutorial for court staff. Please find attached a printout of the tutorial Judge Gull sent the defense, marked as Exhibit B, which also includes the quote-unquote cheat sheet referenced in the letter from the Office of Court Services. Okay, let's go to Exhibit B. Let's blow this up. This is just too much. She like tried to make them look stupid, and they're like, hold my beer. As a reminder, okay, who's this from? This is to all judicial officers and circuit clerks from the Director of Legal Support and Statistics, proper processing of ex parte filings in Odyssey, which they didn't even use. They weren't even filing in Odyssey anyway. As a reminder, ex parte is a Latin term by or for one party. The term refers to an attorney's or unrepresented party's communication with a judge or legal proceedings conducted with notice to and outside the presence of the other parties. Typically, the ex parte proceedings are permitted only when a party needs urgent relief that cannot wait until the adverse party is informed of the request and given an opportunity to respond. Ex parte court documents that are filed via e-filing or conventional filing must be handled differently than other filings. Documents that are ex parte should be marked with the document security group access limited to court and clerk. This ensures that other parties or attorneys cannot access the filed documents. See the cheat sheet on how to process ex parte filings in your e-filing review queue in order to make sure these documents are marked properly before they are added to Odyssey. Choosing the wrong document security group will expose the filing to other parties. If you have questions about the various document security groups in Odyssey, please contact the help desk. Okay, so this is the attachment to that document. Oh, Jesus, criminy. Ex parte filings must be handled differently than confidential filings to ensure unattended parties do not have access to the documents. If an ex parte filing is marked confidential in Odyssey, attorneys for all parties will have access to the document. These filings must be marked with a document security group of access limited to court and clerk. The ex parte filing should be reviewed by the judge before being accepted into Odyssey to ensure the security. Once the judge has reviewed the filing, they will instruct the staff on how to proceed. Oh, shit. Odyssey is a software owned, blah, 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 blah. Okay. So this goes through and walks them through how to put it in. The reviewer signs into their Odyssey file, not the submitter, the reviewer. You click on that, the hyperlink, you click on the forward and the actions, change it to the judge review queue, so then they can therefore tell the rest of the staff what to do. None of this is what the attorneys can do. The people filing cannot do this. The judge signs into their Odyssey. Judge reviews all the filings by selecting the documents from the drop-down menu. Once the review is complete, using the process notes found at the top, the judge will leave instructions for the reviewer, accept the motion with the access limited to the court and clerk security group. Oh, this is where the problem lies, is she has to do something. She's not going to do anything extra. Once the process note has been entered and saved, the judge forwards the envelope back to the appropriate review queue. This is all for them. I know that's what they said, but I mean, it really is. Manual ex parte filing process, scanning the document to the event. Once the judge has directed you to process this ex parte filing, create 2 events. That's for the staff as well. When adding the notice of inclusion, select the notice of inclusion of confidential information and public security group when scanning the document. Freaking A. And this doesn't even have anything to do because they use the docs pop, and which is what they're also saying. Like, she's thinking that she taught us something, and they're like, no, you didn't teach us shit. We were already doing it right. Even though on its face, this tutorial clearly appears directed to assist court staff in understanding how to process and accept ex parte filings, the defense's staff still reviewed the tutorial sent by Judge Gull to determine whether any part of the tutorial was meant to assist a practicing attorney in how to file an ex parte document, and it does not. When defense staff clicked on the link detailed in Step 1 and attempted to sign in, they were presented with a prompt that states, "You are not authorized to use this site." This is because, again, the tutorial that Judge Gull proclaimed in her order as helpful to the defense was actually meant for court staff. I have to cough. Hold on. Dean, it's not a motion, so it doesn't need to be granted or denied. It doesn't matter. Judge Gold's going to deny it anyway. She's going to be like, file an ex parte. You guys don't know what you're doing. Oh, shit. This cracks me up that she's like, and I think it's probably funnier because I can hear specific people that are very pro prosecution being like, look, Judge Gold was even nice enough to send them the tutorial on how to do things right. It's not even the right shit. You know damn well that that's what they're going to do. She went out of their way, and obviously they just didn't even understand it because they're just stupid defense attorneys. Judge Gold is so stupid. Judge Gold has failed to admonish the prosecutor McClellan for improperly reading the ex parte pleadings while continuing to denigrate the defense counsel. Yeah, no, he's fine. Because it was their fault. It's their fault that he even was able to see it, not her staff's fault, and not his fault that he doesn't know how to fucking read where it says ex parte and he knows that's not from him. I just can't get past the stupidity of this. This is so bad. It's so stupid. And then she's like, I'm so smart, and I sent them, look at how you do it, and I taught them, and they did it right every time since. Like, good job, guys. You actually listened, and see, now we don't have any problems. And they're like, no, fuck that. We did it right the entire time. The defense became aware that Prosecutor McClellan read the ex parte documents based upon a March 6 prosecution filing in which the prosecution directly quoted from the defense's ex parte filing from February 26. This document was clearly marked in capital letters at the top of the document, ex parte pleading to be placed under seal. And Nick's like, ooh, that's me. I'm the seal. Let me look. Let me look. It's not Nick's fault. No, it's not Nick's fault. Oh, shit. I just can't even. And then people are calling this a ding dong document. They have to be referring to Goal and Nick, like the fucking ding dongs that they are. There's no way, right? I can't even handle it. It's so stupid. I just feel like the stupidity in this case is just continue. You think it can't get any stupider. Stupider is not even a word, but I'm going to use it here because it's so fitting. It's a bizarro world, man. You're right. This doesn't even make any sense. Ex parte means read me. Nick's like, ooh, is that? That's like a little surprise for me. Ooh, yeah, I get to read it. Didn't she call him a ding dong about how long it was going to take him to go to the bathroom? Go has ruined the movie Dirty Dancing for me. Every time I hear Frances in the movie, I see her instead. Only after gaslighting them, I'm sure. They probably did it. No wonder they just cannot get along. They're just like, she's just like, I think these guys are like Dumb and Dumber, and they're like, no, legit, like you don't have any fucking idea what you're talking about, and you keep trying to tell us what to do, how to do our jobs, when you don't have a fucking clue how to do our job. And that's like why he says, like, you don't, no disrespect, or what does he say? How did he say it? How did Rosie say it? Where he was like, you don't know anything about this case. I can't stop laughing, Steven. I can't. It's so absurd. I mean, and this absolutely is not even a necessary part of this document. I mean, they literally are putting it on the record to be like, look, she likes to just treat us like we're fucking idiots, and yet she's acting like she's doing the right thing when she can't even, she doesn't even know what the hell the right thing is. Yeah, he's like, you're a fucking idiot, with all due respect. You don't know anything about this case. If I ever call you a ding dong, no, I'm flirting. Where do we start talking about birds? I hate birds, and I'm terrified of them. They are vicious savages. What? No, birds are not real. Don't. Oh, that's where the birds comes in. Birds are not real. Don't be ridiculous. I will send you a tutorial on what birds really are. Man, I'm like hot. I gotta turn my fan on. Hold on, real quick. Okay. The pigeons in New York are like an extremist. Oh shit! I had to use the lid off the trash can as a shield. I thought I was gonna die. It was Brando. Oh shit! Like a metal trash can, I could totally see it. I can totally see it, Sophie. My neighbor, when we were growing up, had a goose that would attack my brother in the private area. I bet your brother doesn't like geese at all. I'm laughing at your trauma. Absolutely. We can't laugh at each other's trauma. What are we here for? Oh, it just says, well, the crime scene told me. I really hope the crime scene told the female trainer to leave Massachusetts immediately and never return. I'm hot. I mean, I don't know. After this, I fucking probably need a beehive. Hi, Charmaine. I don't even know how to take some of this stuff seriously. Okay, hold on. After reading Prosecutor McClelland's March 6, 2024 filing and realizing that McClelland had reviewed a defense ex parte document, Attorney Rosie sent an email to Judge Gull and one of Judge Gull's staff members, as well as to Nick McClelland. Find the attached copy of said email marked as Exhibit C. The email respectfully questioned how an ex parte motion was made accessible to the prosecution. All right, let's go to Exhibit C. Hopefully, there's no Judge Gull responses, because we all know how Gull feels about her email correspondence ending up in court filings. She doesn't like that at all. Yet she has no problem blasting the shit out of everybody else's email and putting it in the court filings, even ones that have nothing to do with shit. All right, this is okay. Judge Gull, you may be aware that I filed an ex parte motion for funds on 2/26/24, which contained confidential information regarding our client's defense. We have double-checked and confirmed that only 2 individuals CC'd on the motion were myself and Andy. This morning, I received an e-notice of a filing by Mr. McClelland requesting Dr. Westcott's records, and in his filing, there exist specific quotes from my ex parte filing on 2/26. Unless I am missing something here, this would suggest that Mr. McClelland has a copy of my motion. Naturally, this is concerning. In an effort to not jump the gun on this, my staff member did reach out to Karen in Carroll Circuit Court to confirm that she processed the motion in accordance with the ex parte confidential filing procedure, and she assured my staff that she did. I am not looking to point fingers here, but I think it's fair for me to inquire as to why our client's ex parte filing is not being treated as a confidential filing. I also think it's fair to inquire as to why the prosecutor would not only read the filing, knowing that it is noted as an ex parte pleading to be placed under seal, but moreover, why after reading the filing, the protected information would be reduced to a pleading and publicly filed by the state. Not only does he read it, but he has no issue putting it in his own motions and being like, hey, look at the info I got. Oh, thank you, Dean. I appreciate that. Thank you so much, Dean. Why after reading the filing does he just go, yeah, I'll just go ahead and put that in my pleading? In a normal situation, I would simply pick up the phone and call Mr. McClelland to get to the bottom of this matter. But he has already made it clear to Andy and I that he will not communicate with us over the phone. I have no interest in engaging in dueling emails over such an important matter. So I am seeking your assistance as the fucking judge on the case. I would appreciate your thoughts on this and how to remedy the situation. Of course, I am open to Mr. McClelland's input as well. And finally, I'm happy to discuss this by phone. Also, there is the fact that the state's pleading is currently accessible to the public. Can't put the genie back in the bottle, but the remedial measure of removing the filing would be appreciated. I look forward to hearing from you. Okay, so the Carroll Circuit Court says that it was done correctly. Now, I'm wondering, this whole ex parte versus confidential filing thing is the part that I think might be a hindrance, because when we were looking at, I think it's Exhibit A, all of these are filed as confidential. And then this is for the Odyssey thing, though. We actually need the Docs Pop one, even if it is for the staff, to show what they would have had to have done. But if it was under the Odyssey, they file it as confidential. The clerk has to go in and make it so that it goes to the judge. But they use this other thing. So I'm not even sure that we can actually tell the difference in the whole confidential versus ex parte. But no, regardless, the damn thing is named ex parte. Hammy says literally anytime Gull says, I don't want to point the finger, you know, she's like doing hand exercise. She's like, I'm about to point the finger. I'm about to point the finger. Right, Teresa? I think that's why, like, at this point, like, it's just laughable, because, like, does this even, like, it's so, they don't like each other. The defense team doesn't like her. She does not like them. I don't know how she thinks that she can actually preside over this case and not have bias. It's mind-blowing to me. She absolutely does. I'll just send you an article Indy Star just published. Okay, cool. Thank you. The legal system has gone off the rails in the year of Odin 2024. All right, let's go back over defense filing. Exhibit C. We just did that one. Then on March 7th, 2024, Prosecutor McClelland filed a pleading in which McClelland, finally admitted that he also had access to 3 other ex parte filings. Footnote number 4, after reviewing the record, the defense believes that Prosecutor McClelland actually reviewed only 2 ex parte filings. As 2 of the filings that he referenced in this pleading he identified as ex parte are not actually. Does fucking Nick know what an ex parte filing is? Why is this so hard for him? Despite the clear marking of ex parte on the documents, Prosecutor McClelland chose to read those ex parte documents rather than promptly deleting them and alerting the defense of the misdirected filing. As required under Indiana Rule of Professional Conduct, a lawyer who receives a document relating to the representation of the lawyer's client and knows or reasonably should know that the document was inadvertently sent shall promptly notify the sender. No, Nick doesn't do that. He's like, ooh, it's like I got a special present. I got a present. See, the legal trick box is that earlier in the motion, and presumably in any future hearing, to consider Allen's transfer to a jail instead of a prison, Allen's attorneys will call Gull as a witness. Did you send, is it, let me pull up Discord. Can I get a witness? Ah, shit. Wrong one. That might load at some point. Let me see. Okay, so Delphi murder suspect. Let me download this real quick so I can pull it up on the screen. Maybe. Oh, shit. Hold on. Yes. Okay. So this is the Indy Star. Delphi murder suspect attorneys plan to call Judge Gull as a witness. This is from today. Thank you for sending us. The thinly veiled discontent between Delphi murder suspect Richard Allen's attorneys and the judge and Carroll County prosecutor Nicholas McLean is summarized in the Tuesday filing. Allen's attorneys say they plan to call Judge Gull to testify to the truthfulness of the Carroll County Sheriff's Office report. Deputy Tobe Lesenby allegedly told a deputy in March 2023 that Gull gave permission to ignore Allen's subpoena for an inmate to be brought to court to testify about Allen's abusive treatment in prison, but in Gull's May 31st, she wrote, the decision by the deputy to leave was not directed by the court. This is what we read already. The motion states Gull's statement in May 31st order makes her a witness for the defense in its allegations that law enforcement has not been truthful in its murder case against Allen, who is accused of killing Delphi teenagers. Judge Gull should recuse herself from this matter as she is now a witness. The motion indicates the defense plans to call Gull as a witness at a future hearing. The motion also addresses McLeland reading of defense filings ex parte. Gull accused the defense of incorrectly filing the ex parte motions, but Allen's attorneys filed an exhibit that suggests the procedure they used is correct, but court staff incorrectly gave it to McLeland. This court has failed to reprimand the prosecution for reading those orders or the filings. In parroting Gull's ruling on whether Allen's attorneys were in contempt of court, Tuesday's motion states, nor has Judge Gull filed a pleading in which Judge Gull, publicly proclaimed that she is referring Nick McLeland to the Office of Judicial and Attorney Regulation. We haven't got there yet. In its closing paragraphs, the motion notes that the public's perception is that Gull is biased against Allen and his defense team. The motion states its purpose is to preserve the record and respond to Gull's order. The defense wishes to move forward and have this court conduct a hearing. Most immediately, the request of Richard Allen to be moved, the legal trick boxes that earlier in the motion, and presumably in any future hearing to consider Allen's transfer to a jail instead of a prison. Allen's attorneys will call Gull as a witness. The legal trick box. I love that. All right, let me get back over here. All right, let's go back to the defense. Where do we leave off? Prosecutor McLeland never contacted defense counsel after receiving the ex parte documents as required. The defense only learned of this violation upon reviewing McLeland's filing on March 6th, which McLeland audaciously quoted directly from the ex parte document, thereby making said quote available for public view. The act of McLeland reading from defense's ex parte documents provided the prosecution with an entirely improper glimpse into the manner in which Mr. Allen's attorneys would be defending him. This is yet another example of a subversion of Richard Allen's due process rights. This court has failed to reprimand the prosecution for reading ex parte documents or to even address that issue in any way whatsoever. Nor has Judge Gull filed a pleading in which Judge Gull, publicly proclaimed that she is referring Nick McLeland to the Office of Judicial and Attorney Regulation, Executive Director Adrian Meering, for that office to enforce the rules or determine counsel's ethical misconduct. Remember, she makes sure to put that out for them. Hold on, let me go to footnote 5. This quote is taken from Judge Gull's April 30th, 2024 order of judgment of the court concerning the prosecution's request that defense counsel be found in contempt. Yeah, she's not doing that. She's not going to do that to poor Nikki. She's going to blame it on the defense. DV says, I only have the illegal trick box. Oh, shit, that's funny. I'm making a pizza. My own personal pizza parte. All right, let's go back up. Where do we go here? Hold on. I think I went back too far. Here I did. Here it is. So that was 5. Okay. This court publicly declared in its April 30th, 2024 order that it was referring defense counsel to the Office of Judicial and Attorney Regulation concerning a short and bland press release that defense counsel sent out to media sources when no gag order was in place, and after the prosecution and law enforcement had conducted multiple press conferences and issued multiple press releases over the course of the investigation. Meanwhile, on the much more serious allegation of McClelland reviewing ex parte documents and violating IRPC 4.4b, Judge Gohl has said or done nothing. Judge Gohl is clearly treating the prosecution differently than the defense counsel, and this provides a rational inference of bias. How long should I put pizza rolls in the microwave? 45 seconds. Flip them over, do another 45 seconds. That's how you do pizza rolls. This court offered its hand-picked. This court offered its hand-picked public defenders an opportunity for a hearing on the Franks motion, but denied the same opportunity for attorneys Baldwin and Rosie. In her May 31st, 2024 order denying the defense's request for disqualification, this court maintained that it has no bias against the defense counsel. On January 22nd of 2024, this court denied Baldwin and Rosie's request for a Franks hearing. At that point in time, this court had failed to rule on the Franks request for over 4 months. Yet within 4 days of their re-entering their appearances on the case, Judge Gohl denied their request without a hearing. However, after Baldwin and Rosie were taken off the case in October 2023, Judge Gohl informed her newly hand-picked public defenders that they should review prior counsel's pleadings and either adopt these pleadings or make their own. In that November 14th, 2023 CCS entry, it was memorialized that Judge Gohl informed the new public defenders, Scremin and Librato, that, quote unquote, if defendants' new counsel inform the court they intend to pursue the Franks motion, the court will schedule a hearing. Oh, Teresa, you go to bed? I might have missed it. No, I'm not. That's how long I cook them for. Such action demonstrates that this court is punishing Richard Allen due to her bias against attorneys Baldwin and Rosie, and that after they re-entered their appearances, she quickly denied Allen's original counsel a hearing on the Franks motion while offering the replacement public defenders an opportunity to have a Franks hearing soon after their appearance on the case. This disparate treatment of attorneys Baldwin and Rosie compared to this court's treatment of the prosecution and even of the replacement public defenders provides a rational inference of bias against defense counsels Baldwin and Rosie, and therefore against Richard Allen. In its order, this court claimed that it is irrational and unreasonable for the defense to assert that as lawyers with 70 years of combined experience, they have never had a judge provide a hard end date for a trial. Calling defense counsel irrational and unreasonable shows bias, especially when the court is wrong in its understanding of Jury Rule 4. This is what we were talking about. Hold on one second, you guys. This court unfortunately continues to malign defense counsel by calling them irrational, unreasonable for their averments that courts around the state of Indiana never set a rigid day for the trial to end. Implicitly, the court is also averring that defense counsel are lying about their experiences in other courts around the state of Indiana. Furthermore, this court maligns defense counsel concerning its knowledge of the jury rules when it is the court that is incorrect in the assessment of the jury rules. At the May 7, 2024 pretrial hearing, the court stated, well, you understand. Well, maybe you don't understand. Jury Rule 4 requires that I issue summonses to the jury with the dates of the trial. Jury Rule 4 requires that I issue a summon to jurors with the dates. That's on the transcript. We have that. The court cited Jury Rule 4 as a basis for limiting the time of the trial. However, Jury Rule 4 does not ever discuss the length or dates of the trial or require courts to place a hard end for a trial. Jury Rule 4 states that, quote, not later than 7 days after the date of the drawing of names from the jury pool The jury administrator shall mail each person whose name is drawn a juror qualification form and notice of the period during which any service may be performed. Jury Rule 4 is primarily referring to the time span or term during which citizens need to be on the alert that they could be summoned for jury duty, that they are quote unquote on call for possible jury duty. The prospective jurors need to be aware that over the course of a specified number of months, the court may summons them to appear in court as a potential juror at a later date. Jury Rule 4 further states that when summoning a prospective juror in for jury duty, that, quote, the summons shall include the following information: directions to the court, parking, public transportation, compensation, court policies regarding the use of electronic communication devices, cell phones, PDAs, smartphones, attire, meals, and how to obtain auxiliary aids and services required by the American with Disabilities Act. It's okay. If you can't hear, she'll just offer you a hearing aid. Note that Jury Rule 4 does not require the court to provide the dates of the actual trial or the length of the actual trial, nor does Jury Rule 4 require the prospective juror to be advised of the beginning or end date of trial. Jury Rule 9, term of jury service, states a person who appears for service as a petit juror serves until the conclusion of the first trial in which the juror is sworn, regardless of the length of the trial or the manner in which the trial is disposed. Once summoned in and selected as a juror, Jury Rule 9 is the jury rule that comes the closest to referring to the length of the actual trial. Note that Jury Rule 9 places no limit to the length of an actual trial once a juror is selected, nor does Jury Rule 9 place a hard end on the conclusion of any trial. Indeed, by stating that the juror serves until the end of the first trial, regardless of the length of the trial, the authors of the jury rules innately understand that courts will not have foresight to include an actual end date to trial. As proof, in larger counties, jurors are summoned for a particular day and could be chosen to serve on any number of trials of varying lengths. Footnote 6, let's see. In Marion County, for example, prospective jurors arrive and gather in a large room not knowing which court or what trial they may be called upon to serve, as often multiple jury trials are conducted at the same time and on the same day. The prospective juror could be asked to serve on any one of those trials. In spite of Judge Gold's proclamation at the May 7, 2024 hearing, Indiana jury rules do not provide or require a mechanism to limit the length of the trial whatsoever, including as it relates to the information contained in the jury summons that the court sends to citizens, pursuant to Jury Rule 4. Judge Gold's errant interpretation of Indiana jury rules creates a situation in which Mr. Allen was required to seek a continuance of his speedy trial in order to assure for himself a trial where he could thoroughly present his defense without time restrictions. Judge Gold's bungling of Mr. Allen's speedy trial right due to her misunderstanding of what the jury rules require in the summons only negatively affected the defendant and his constitutional rights, not the prosecution, and thus provides a rational inference of bias against the defense and Mr. Allen. I don't even know if I want it. Yeah, go blaming this on Jury Rule 4 was stupid as hell. Yeah, we went back and looked at it, and all it talks about is in the questionnaire is just asking if they'd be available during like such and such time, not like, oh hey, we're not going to keep you after that. Like I've never heard of that in any trial I've ever watched. I mean, shit, could you imagine right now? Lolly would have just taken up the entire court case of Karen Reed. All right, give me one sec. Okay. Let's see. Additionally, at the May 7, 2024 hearing, Judge Gold cited several cases over which she has presided that lasted less time. I know, this is so dumb. This is so bad on her part. I was like, this is not You think this is like a positive. This is not good. You're just showing that you don't really give a shit about people's due process rights, and you have no problem shutting them down whenever you think that needs to be shut down. Judge Gull cited several cases over which she has presided that lasted less time than the defense is requesting on this case, essentially chastising the defense for the amount of time it was seeking for trial. The length of a trial is determined by the number of witnesses, the amount of evidence, the length of the investigation, and the complexity of the issues involved. This is the case of the state of Indiana versus Richard Allen, with its own set of facts, challenges, and potential pitfalls that could cause the trial to last beyond what the parties expect. For example, several witnesses reside 125 plus miles away. If those witnesses fail to appear in spite of being properly subpoenaed, the trial may be delayed while the parties try to determine how to deal with a witness whose car may have broken down or who may have simply ignored a valid subpoena. These situations arise in trial, especially in a factually complex trial with approximately 185 witnesses identified by the parties. Additionally, of the approximately 185 witnesses identified by the parties, a dozen or more are expert witnesses whose testimony will generally take longer and will be more complex than the fact witnesses. For this court to call defense counsel irrational and unreasonable for stating the truth that they have never had a judge set a hard end date to a trial provides a rational inference of bias against the defense. Additionally, it is shocking and disconcerting that the court refused to place a limit on the time allotted to the prosecution, but absolutely limited the time for the trial, thereby limiting Mr. Allen's time to present his defense. Now, in fairness to the prosecutor, at this point, when they were having this hearing, he said, "Oh, I've narrowed it down. You know, it was like 140 or 150 or whatever, but I've narrowed it down to like 45." But then to go back to the defense's point, well, we don't know what 45 or whatever it is he's narrowed it down to. So we still have to actually prepare for cross-examination on every single one of those 140 witnesses that he has on that list. So until he tells us, we still have to prepare for everybody on the list. Under the court's prior order, the trial was to last from May 13th through May 31st, thereby allowing approximately 13 days for opening statement, testimony, evidence, rebuttal evidence, surrebuttal evidence, arguing of final instructions, and closing arguments of both parties. If the prosecution took 8 days to present their case, this would only leave 5 days for Mr. Allen to present his witnesses, which include at least 5 expert witnesses without even factoring in rebuttal evidence, surrebuttal evidence, arguing of final instructions, and closing arguments. The hard limit on the end of the trial denies Mr. Allen his Sixth Amendment right to confront witnesses, his Sixth Amendment right to the compulsory process for witnesses, and his 14th Amendment due process rights to present a defense. They're absolutely 100% right. In the context of its request for Judge Gull to disqualify herself, this court's maligning of defense counsel as irrational and unreasonable, when in fact it was this court that was wrong in its understanding of jury rules and also wrong in its claim that courts statewide provide a hard end to a trial, offers a rational inference of bias against the defense. Judge Gull's May 31st, 2024 explanation for her denial of defense motions without a hearing provides a rational inference of bias. All right, let's check on you guys real quick, and then we'll keep going. We're getting there. We're almost done. I think she's for sure not going to recuse. No, she does. She wants to like hammer these guys, and now she like wants to save face, so she won't back away. There, I screenshotted both comments so I can see I was right no matter what. I didn't even notice you had both of them on there. She won't leave unless she's removed. She will never. Turn camera on for the last part. Oh, serious? You want the camera on? Okay. Well, it's just hard because I'm like looking over here anyway to read. Hi, Slows. Criminality. So is this asking for another recusal, or was it what is it doing? Why are they not doing or asking for an IA? They're not going to, I do not believe they're going to ask for an interlocutory appeal based on the fact that she would be the one who has to approve that. She'd have to say they could have it, and she's not going to do that. My original thought process when she denied the recusal was that we were going to be looking at another original action. But I thought we were going back to the Supreme Court. And then Kara made a comment on Twitter that made me go, well, I guess that's not true. So she commented like, hey, I'm kind of following the case, the Delphi case, like from the sidelines, like same as you guys. And I was like, ooh, that's not good. So I'm hoping that this is just another example or another pleading where so one of the footnotes that they have in here is a judge can recuse themselves or disqualify themselves as the presiding judge at any point. They don't have to have a motion to disqualify in order to make that judgment and to understand that they're in the position that they shouldn't be in. They can make that decision no matter what. So they tell her that, like, hey, you don't need us to tell you or to file a motion to disqualify you for you to actually go away. Like, you know the right thing to do. So part of me thinks that they're like thinking like, hey, you now know that we're going to call you as a witness. You're going to have a conflict. And now the right thing to do would be to walk away because you can't be a witness and the judge. It's not going to happen. So she's just going to do what she did with Nick, though. And she's going to be like, no, he doesn't need to be a witness. She's going to be like, no, I don't need to be a witness. Like, you can get if you can get the evidence in some other way, then you're going to have to do it that way. That's where she's going to go with that. So this is twofold in my opinion. One, it's like wanting her to pay attention, look at it and say, look, Goal, you don't know what the fuck you're talking about. You shouldn't be the judge on this case. You obviously have bias. We're telling you all the reasons that it shows that you have bias. We want to get this to go forward. We want to have this trial, and we want you to not be on it. And we don't want to have to go through an interlocutory appeal. We don't want to have to go back to the Supreme Court. But they're essentially saying like this, we're writing this in case we do have to go somewhere else. We're writing this for other courts in case we have to talk to them because you won't be reasonable. Right. So then, like DB says, when she says no, which she will, they can go, okay, look at, here's more reasons we can add on. Here's more reasons we can add on to an original action with the Supreme Court. She's not going to leave without being told to leave. I just don't know. Can you appeal a recusal to a higher court? So that's essentially, they can do an interlocutory appeal. They have to request one through Judge Goal, though. So that's their one option. So, and that's essentially any type of appeal that's happening during the process. So you typically hear about appeals like, after somebody's found guilty and then they're going and appealing their sentence or they're going and appealing their conviction. So they have to file for an appeal during the court process, but she has to approve that. The other thing, the next one is to go back to the Supreme Court. But that's what concerned me when Kara was like, I'm just kind of watching this from the sidelines. I'm not really involved anymore. I'm like, oh, right now is kind of when I want you to be involved. So like, can you get back in there? Like, you need to get back in there because she's really, in my opinion, going to be one of the ones that would end up writing the original action to go back to the Supreme Court. So her saying that kind of made me go, ugh, what are we doing? She needs to be classy and go, but she won't. She just won't do it. She won't do it. She won't do it because she won't want anybody to think that she is actually biased. The ding dong is coming up. Oh, okay, hold on. I'm telling y'all, Indiana is a good old boy network, and RA will go down for this. Indiana doesn't give a fuck who done it. They just want the money and someone to blame. It's sad but true. I followed it pretty hard until Karen went to trial. Then I completely abandoned it until now. Now I have to catch up on the pretrial since the attorneys came back. Ah. I mean, they're going to call her as a witness. That's going to be a problem. They're going to have to somehow appeal a higher court. Yeah. Her sheriff is asking for prisoner release. I don't know what that one's on. All right, I'm just making sure I have all your comments. Hey, Erica, I've been busier this summer than during the spring semester. You're taking classes? Summer classes are always they're so tight, like the time frame. I mean, you are busier. I don't get it. Anybody else get to bow out and work and they take a nap? Go like, I'm doing this shit, boys, because she won't let them win anything. And if she left, she considered that a loss for her and a win for them, and she's not doing that. She does not. She will not give them an inch. Is this going to give her X amount of days to respond before they go forward? No. This doesn't give her. This is nothing. This is nothing for her to. She doesn't need to respond to it. There's no approve deny, unless there's something at the end that I'm not seeing yet. There's no approve deny of this. I think she just meant that she's watching the case, like the case, Rick's murder case. I hope so, because I'm like, now's like a time that like that they're really going to need you on board. Doing yoga as I listen, so I can deal with my rage. No, I'm hoping that's the case. Maybe I'm just putting them together, and just the way she said it, it was not. I know. It's pretty simple. That's the furthest thing from simple. It's very confusing to everybody. Yeah, thank God the vast majority of judges are nothing like this woman. Well, she'll play very differently to a jury, because she'll be like, oh, jury's my favorite. And then they're going to like look up to her with just utter awe and respect. And I'm going to want to vomit. That's where I'm at. Okay, hold on, please. Son of a biscuit eating bulldog. How much shit did I say? I said so much stuff. It was probably like the most profound words I've ever used, and you guys missed them. I said a lot. I know I did, and I don't even know what I said. Damn it. It was something about Susan being right. I think I was saying that I did say before that whatever the trial ends up being like is different than what we expect right now that it's going to be like. But I think I said it way cooler when you guys couldn't hear me. Son of a bitch. Okay, Judge Gull's May 31st, 2024 explanation for her denial of defense motions without a hearing provides a rational inference of bias. So we're going through all these, the whole list again of all the rational inferences of bias, which before made me think we were going to the Supreme Court. In its May 31st, 2024 order, when explaining why the court denied several defense motions without a hearing, the court stated if pleadings on their face are not supported by law or admissible evidence, judicial economy does not require a hearing. This court knows very little about this case, especially compared to the lawyers litigating the matter. Therefore, how could this court determine what evidence would be admissible or inadmissible until a hearing takes place and the defense moves to admit the evidence, subject to possible objection by the prosecution? Judge Gold's claim that the defense evidence is inadmissible before conducting a hearing and before listening to the defense's contextualization of the evidence surrounding their legal arguments provides a rational inference of bias against the defense. This court's denial of defense motions without a hearing based upon the reasons this court cites in its May 31st, 2024 order establishes that this court is prejudging defense evidence as inadmissible. Which she did also she did that in her email that she was pissed that ended up in the filing, but she does that in there. She's like, you guys, I don't know what you guys think you need 3 weeks for. You don't even have any, you got nothing to present, you got no defense. And then in court, she was like, but if you guys had just told me that you needed all this time, I would have gladly given it to you. And it's like, no, you already told them they don't need that much time. Somebody brought, oh, Erica. That was like my favorite movie growing up. Breaking 2, baby. Yeah, can't recapture the magic now. It's gone. It's gone. How can the judge be a witness, and a witness of what? So they're saying that the judge would be a witness to the fact that she is stating she never told, essentially Tobe Lesenby, to not bring Robert Baston to the hearing last June. But yet the CCSO, Carroll County Sheriff's Office, Tobe Lesenby, and other deputies are saying, no. We ended up leaving because Judge Gold's office told us we didn't have to bring it. If he didn't want to come, don't worry about it. So who's lying? One of them is lying. And so if Tobe takes the stand and is asked these questions, then she would be a witness to impeach him. Or vice versa. I don't listen to them anymore. I have no idea what they've done, Royal We. Hey, Luke, she decides things are inadmissible over breakfast, likely via Snapchat. We have one earbud, though. Share it. Where they sit on each other's laps. How long before everyone gets tired of being Gold's sacrificial lamb? Oh, bullshit only flies for so long. LOL, anyone ever seen Lord of the Flies? Mm-hmm. You know who else is a witness then? Judge Diener. I don't know. I think something bad's going on with Diener, and I don't think nobody's gonna want to use him. She lied on the damn stand about the defense leaving. That was on the judge's throne. That should be the next live. 50 Shades of Fuckery. I wonder if Tobe would take the fall for Gold. I don't think so. Liggett, on the other hand. Okay. This court's denial of defense motions without a hearing based upon the reasons the court cites in its May 31st, 2024 order establishes that this court is prejudging, did I already read this, defense evidence as inadmissible. Also, this court's claiming that the law does not support the defense pleadings before this court even hears any evidence is additional proof that this court is prejudging evidence. This court's denying the defense's request contained in its pleadings without a hearing based upon her prejudging evidence provides a rational inference of bias. In the future, if this court denies defense motions based upon the court's belief that the defense pleading is not supported by law or admissible evidence, the defense then requests this court to identify the evidence cited in the defense's pleading that this court believes is inadmissible, and then to explain why the court believes the evidence is inadmissible, also instead of simply stating denied without a hearing. The defense will request the court to explain why the pleading is not supported by the law. Even concerning something as basic as a request for a recess, Judge Gall shows favoritism to the prosecution. In her May 31st, 2024 order, Judge Gall expressed that she does not show favoritism to the prosecution. However, Judge Gall has shown her differential treatment between the prosecution and defense in a variety of ways. Some are easily identified and some are less perceptible. For example, because cameras have not been allowed in the courtroom, it is difficult to hear Judge Gall's angry tone when addressing the defense versus how she speaks to the prosecution. Many people that have been in the courtrooms have said that that's a huge thing, as like how she speaks, her tone and tenor, as Bob would say. Versus how she speaks to the prosecution, and also to visualize the court's disdainful facial expressions that she makes toward the defense versus the prosecution. This has a footnote. Let's see. In the future, the defense will likely request cameras in the courtroom for all hearings and trial for purposes of transparency and to better preserve the record. Oh, I have questions. Thank you for the super chat. Wait, judge lied on the stand about what? She didn't lie on the stand in her last order. She's saying that she never said that to Tobe Lesenby. But Tobe Lesenby and Deputy Brian Wysocki both say that she did. So that's a problem. So she's either lying or they're lying. And if they're lying, that means that she's known they were lying for over a year or almost a year. We demand the camera. Yeah, they're gonna ask for it. She's gonna deny it. Okay, let's see. Where were we at? What is that? Footnote 7? Where was I? Somewhere up here. Okay. Although it may seem petty or trivial to the court, the defense offers an example of her disparate treatment concerning something as mundane as how the court handles a simple request for a recess during a hearing. At the June 15, 2023 hearing, Prosecutor McClellan requested a recess, and the following transpired. Judge, I do. I have 2 witnesses. Could I ask the court for a short recess so I can use the restroom? Judge Gohl, would counsel approach? Judge Gohl, I just want to know kind of where we're at. You got 2 witnesses? McClellan, Tony Liggett and the Westfall warden. Judge Gohl, okay. Do you want to break for lunch? Rosie, I don't, but I'm Judge Gohl. Okay. So McClellan says, so I don't care. I can. Judge Gohl says, yeah, we could take a quick break. How long? McClellan says, I don't mean to be a pain, but Gohl says, no, that's all right. How long do you think you'll be? And McClellan's like, downstairs and right back up. No. I mean your witnesses with your evidence. McClellan's like, oh. And then she's all ding dong. I don't care how long it takes you to go there. No, I don't care about that. I don't really think too long. Tony about the transportation resources, and then Gallipo just to address the allegations they made in their safekeeping. Yeah, we read that part. He's like, I gotta go to the bathroom. She's like, I don't need to know how long it's going to take for you to go to the bathroom, fucking idiot. You ding dong. So like another hour and a half. McClellan says, I guess I just couldn't. Judge says, let's just break for lunch. I know you don't want to, but too bad. Rosie says, I'm fine with whatever. Judge Gohl says, okay, let's just break for lunch. Rosie, I don't have anywhere else I need to be. Judge Gohl, well, I know you don't because you were supposed to be here for 2 days. However, at the May 7, 2024 hearing, the court treated the defense much differently when the defense sought a short recess to confer with their client on urgent matters concerning the positives and negatives of continuing Mr. Allen's speedy trial due to Judge Gohl's hard end date of May 31st. Following a back-and-forth exchange between Judge Gohl and defense counsel concerning the defense's needing more time for trial that Judge Gohl was allowing, this occurred. Rosie says, can we have a 5-minute recess? Judge Gohl's like, why? Rosie's like, I would like to speak with my co-counsel here and have a discussion about the business issues such as scheduling. Not here in a courtroom where everybody's listening to us. We've got, 50 staff members in this courtroom, people sitting behind us. There's no privacy, and I'd like to talk to him in the hallway about some of the logistics of this so we can solve the problem so that he, Mr. Allen, can put on a defense. Rosie's problem right there is she said, I'd like to talk to him in the hallway. Just going to say. Judge Gohl says, does the state of Indiana have any objection to a recess? McClellan's like, no, Your Honor. It's fine. You can go to the bathroom. Judge Gohl says, all right, Jody, you can go off the record. Judge Gohl did not playfully call Brad Rosie a ding-dong, but instead questioned Rosie's reasons for seeking a recess. Then Judge Gull surprisingly asked the prosecutor if he had an objection to seeking a 5-minute recess so that the defense counsel could talk to their client about the important matters concerning seeking a continuance of a speedy trial due to the court's unwillingness to provide more time for the defense at trial. When a defense attorney requests a 5-minute recess to talk to their client on such weighty matters as their constitutional rights related to continuing a speedy trial, it should be met with a simple, of course, and should not require the approval of the prosecutor. Judge Gull always requires the approval of Nick. She constantly asks him, like, Nick, what do you think? Do you think that these guys are good attorneys or no? Do you think we should get rid of them? And Nick's like, oh, fuck yeah, I would totally get rid of them. She's like, okay, sorry guys, you're out. She always needs Nick's approval, that ding dong's approval. This court failed to address the appearance of bias which exists in this case. Judge Gull claims in her order, as counsel should know, criminal cases are tried in a court of law and not in the court of public opinion. However, the standard for recusal is not just whether actual bias exists, but also whether the appearance of bias exists. Okay, there's a footnote. Let's take a look. Number 8, the mere appearance of bias and partiality may require recusal if an objective person knowledgeable of all the circumstances would have a rational basis for doubting the judge's partiality. So not the ding-dongs. The ding-dongs don't have to think that. I think like Rosie's saying something like, Judge Gull didn't playfully call me a ding-dong. Like, it's okay. I think you're going to be okay. I think you're going to survive that. The judge must consider both actual bias and the appearance of bias when determining whether to disqualify herself. Judge Gull appears to conflate the general concept that on occasion the public will vehemently criticize a judge with the defense's specific intention that many in the public are particularly criticizing her for what the public perceives as actual bias against the defense. Footnote number 9. As part of the legal reasoning contained in her order, Judge Gull cites to being threatened with bodily harm and injury. She is not alone, as defense counsel has also received death threats and threats of bodily harm. Regardless, the defense sees no linkage between whether an appearance of bias exists and Judge Gull's mentioning that she or any other party has been threatened. I'm pretty sure that they're probably all they probably all have their fair share of really weird people who want to contact them. So I believe that. I've just been on social media long enough to know that some people have no couth. I don't even know what else you'd want to call it. But I can absolutely think that probably every single one of them has been threatened by some person in some way. I don't think it's a personal. I mean, it is personal. Don't get me wrong, but I don't think it's not just one. They're all being. I think they're all probably getting some type of like, here, you suck at life. You need to go. Does Franny have a crush on the oily bohunk? I don't know. She's like, you ding dong. I don't need to know how long it's going to take for you to go potty. Just go. Hi, Lynn. It doesn't end up working for the defense. They need to stop trying. They may get stuck with her, and they need to consider that. I agree with you. I think that at this point, we kind of they're going all in, and if it doesn't work, I think that's kind of where they're at. Then it's like, just get back on track. Hi, Georgia. Never turn your camera off again. Your voices and giggles are great, but even better when we can see you. Sometimes, like, it's just like the side of my face, like this. So I just feel like, we shall see. We shall see. We shall see. Don't at me. My Miku's headphones. It's not okay. However, it's not unique, and she is a judge. Right. It's not okay, and it's not unique. It literally. Hi, Salty Beach. I can't believe this made it into a motion, but I can appreciate a playful ding dong. I just think it's so funny. You should call me a ding dong. They're calling me a ding dong. They are tampering with a witness. Who? Who's tampering with a witness? Can I get a witness? Oh, you think? Oh, I see. I think I see what you're saying. Hold on. So if Judge Gull ends up having to be a witness, then if they're threatening her, they could actually get in trouble because they're threatening a witness, like tampering with a witness, kind of like a Turtle Boy thing. Is that what you mean? If she's a witness, they have to keep filing these to preserve the record because it will be appealed. Absolutely. At no offense to those who do not live in Indiana and passionate about this case, but in my opinion, Hoosiers have the most to gain and lose when it comes to this case and should have the most leverage. True, but not when it comes to keeping my camera on, Susan. Just joking. I liked the letter that said, ask not what your country can do for you, but what you can do for your country. Don't me. No, they won't, but it's just, I get it, though. Okay, so let's see. Where are we at? The emails which the defense attached to the motion and the memes the defense referenced in the motion detail how the public believes that Judge Gull is biased against the defense. So she was like, I don't care about those. I don't care what people put on social media about me. The defense agrees with this court that the general complaints by the public concerning the court's rulings should not cause her to disqualify herself. However, that is not what the defense is discussing in its motion. Okay, footnote number 10. It is true that many in the public have written both Judge Gull and the Indiana Supreme Court to complain that the judge is wrong in various rulings, particularly whether the judge should allow cameras in the courtroom. However, these complaints would not support an appearance of bias. Okay. So they're on the same page with that, I guess. Although the defense believes actual bias exists, it is the appearance of bias against the defense about which the public has complained. Very true. It is well, some are just fucking weird and they just want to complain about other people on social media and they just want the judge to know it. I don't know. It is the appearance of bias against the defense about which the public has written to the Indiana Supreme Court. It is the appearance of bias against the defense about which the public has written to Judge Gull. And it is the appearance of bias against the defense, the existence of which Judge Gull should recognize and for which Judge Gull should voluntarily recuse herself. There is absolutely an appearance of bias. And I know I've said this before. I don't know if I've said this one for quite a while because I sometimes repeat some of the things I believe. But like I said, I don't think I've said this one for a while. But so the defense team has obviously put in a ton of time to work with their client. The client still chooses that this is the defense team that he wants. And you can't replace the defense team without screwing with the due process of the defendant. And I don't just mean this for Richard Allen's case, just in general. Now, at the very beginning of this case, I believe that Nick McClelland should have gotten a special prosecutor. He does not have the resume to prosecute a case of this magnitude. Not that he couldn't have been on it at all. Even with the familial relations, like he's not blood relatives, but he's somewhat family connected to the Patties. But I do think with a special prosecutor, he could have stayed on the case, but he didn't need to. Special prosecutor should have taken over. But obviously, down the line, he is now the one that is involved and has the most knowledge about the prosecution side of the case. So I'm glad that he ended up bringing on other people. I think that was important to do. So you can't really just get rid of your prosecutor without having anybody to back that up. Now he kind of does. He's got Luttrell and he's got Diener, who are now more informed about the case. The thing about a judge, and why to me this is so frustrating, is the judge is the finder of law at a trial. The jury is going to be the finder of fact. They have to determine who they believe and what they determine to be the facts of the case after they're presented with all the evidence. But the judge is the finder of law. They have to know the law. If you have a judge that's in this courtroom and they know the law, we're just going to pretend like she does, you can pick that judge right up and put in another judge that should also know all the laws, right? Or be able to have access to them if they need to in their chambers, and put that person right in. They don't have a tie to the case. They're not a necessity to the proceedings of the case. You can take a judge out and put another judge in, and they can still become the finders of law. Does that make sense? So for me, the reason this, and I think I have such an issue now with just her in general, is she knows that. She knows that she is not a necessity to the case. And as much as I could care less about McClelland, he now has become a necessity to the case because nobody took care of it at the beginning. The defense attorneys are a necessity to the case. They're a necessity to the defendant's due process rights. She's not. Even more so, she's not, because she doesn't have any hearings to even hear the evidence or lack thereof or decide anything. So there's no reason that she can't go away, because somebody else can take her spot and not affect the trial at all. So like, this is just continuously pushing just to like, for her own good, like for her own sake. Like, she just doesn't want to be like, no, I'm not going to do it. And it's like, you obviously know there is a perception of bias. There is an appearance of bias against you. Don't tell me that. I mean, Nick McClelland might be dumb on some things, but don't tell me that Judge Gold doesn't actually know that there's an appearance of bias. If she doesn't actually know that she is biased, that her commentary and her rulings show bias, she's not a necessity. So she could easily pick up and just bounce and be like, see ya, enjoy. I'm going to go talk to my granddaughters about playing softball at the Libby and Abbey Park. So I think what irritates me the most about her is it's that ego, Greenlee. So tired of the ego becoming more important than what his constitutional rights are. And that has to do with whether he's innocent or guilty. Does Judge Gold have dementia? I have no idea. I'm seriously asking, as she is acting like she does. She's confused and forgetting things, not sure if this is due to dementia or on purpose. Or she just, I'm telling you, she's just going to pass the buck. She's going to be like, oh, they said they contacted the office. It wasn't me directly. I didn't talk to Toad. What's not me? She doesn't care. Or for whatever reason, she thinks that she is like the right person to preside over the case. And it's just like, that's the weirdest shit to me. The fourth person is going to be Nick's mom. Not the worst fact per se, but the most eyeballs and public attention. This kind of attention on a case is huge for a judge's career. That's true. Is Luis in here? Did I miss Luis? Where are you at? I saw you in here earlier. I didn't know if you came back. I was off on a tangent and I wasn't reading chat. Yeah, if you ask her, it was probably like in a 3-day trial too. She's like, I gave that guy the death penalty in like 3 days. Sure did. T, think about what you said for a second. Which part? Oh, shit. She is a necessity. She is a necessity for the state. Yeah. Well, yeah, I mean, fucking Nick's not going to want her gone because he gets to have the say-so in all the hearings. She's like, do you want this, Nick? Nick, what do you think? You think we should do it this way? Okay, Nick, let's do it like that. You just silly little ding-dong. You said it's a ding-dong. But doesn't this now create a good enough record to have the Supreme Court remove her? This is creating a good enough record to probably create the original action to go to the Supreme Court. Now, whether they'll actually remove her or not, I don't know. She thinks she is preordained to rule over this case. I agree. She feels like she has like some right to it, or I don't know. It's like the weirdest shit. I mean, and wouldn't you think just an inclination? It doesn't have, I don't mean the whole thing. I don't think she needs to bounce because of it. But as soon as you're constantly being told by one side that you actually are biased against them, and the other side isn't denying it, Like, you don't see Nick coming out and being like too like, nuh-uh, she's not biased against you guys. Like, she's just fine. You don't like Nick just gets to kind of sit back and laugh at this part. Like, don't you think she'd start to pay attention, like everything she says and does, like, ha ha ha? Or did the Supreme Court leaving her on the last time make her cocky, where she's like, I can say and do whatever the fuck I want, and nobody's telling me to leave? So I don't know. That's where I'm at with it. Judge Rush would have if she could have had last time and convinced. Well, so remember they had 3 arguments going in front of the Supreme Court. One of them was a waste. I mean, it shouldn't have even been part of it. But then they didn't even get to really argue this part. And I don't remember that guy's name. Matt Lehman. Maybe I do remember. Is Mark Lehman? Mark Lehman, I think is his name. He was the one arguing in front of the Supreme Court on behalf of the defense attorneys and Richard Allen, and he was saying, like, the most important thing we want to accomplish here today is to get the attorneys back on the case. So the majority of their time that they got to spend, like, arguing their side, that's what they focused on. They didn't even get to really focus on the bias part of Judge Gold. So I don't think they walked out of there thinking that they were going to win that, and because they didn't really do anything with it. But now there's even more. So since January of 2024, we're only in June, and they're citing a lot of things that shows the appearance of bias, if not actual bias. So I mean, I don't know what would the Supreme Court end up saying now. I don't know. I just think it's for me at this point, it's like she doesn't need to be there. And I don't know why she doesn't, like, get that. Like, if you really want justice for this guy, why do you have to be the one to do it? Hi, Gam. Trying to catch up on 2 times speed. T sounds like a chipmunk, and I love it. I wonder how my laugh is on 2 times speed. That's probably terrifying. You freaking ding-dong. Little ding-dongs. They told them to take it back to trial court and do it the right way procedurally. They thought she would recuse. No, they didn't. I disagree. I think Justice Rush did not want to remove her. She picked her for this case. Removing her would reflect poorly on her judgment. Ooh, that's a good point, DB. That's a good point. It was the absence of evidence as the proof of bias. I think I think it has a lot to do with ego. You think there's an actual bias. Like I said, there's something extremely sus about her in the whole case. All right, I think we're coming up right on the end, so we'll finish it off. Where were we at? I think we just read footnote 10. Although the defense believes actual bias exists, it is the appearance of bias against. Oh wait, no, we did read that. Never mind. Failure to address other issues contained in the first motion to disqualify. This court addressed a few other defense issues. Okay, this court addressed a few other defense issues contained in their second motion to have Judge Gold disqualify herself. The defense stands by those reasons as well and does not waive those issues for purposes of appeal. However, in its May 31st order, this court failed to address all issues contained in the defense's first motion to have Judge Gold disqualified, which the defense incorporated into its second motion. The defense requests Judge Gold to review the first and second motion to disqualify and consider whether she feels obligated to disqualify herself from this case based upon the itemized reasons contained in those motions, as well as in this response. That's why I said at the very beginning of this, they told her, like, you don't actually have to wait for us to file something to have you disqualified. You can do the right thing here, Judge, and just fucking leave. The defense wishes to move forward and have this court conduct hearings. Most immediately, the request to have Richard Allen removed from the DOC to either Cass or Tippecanoe County jails while awaiting trial. This motion is intended to respond to Judge Gold's order for purposes of preserving the issues for the record, and so that Judge Gold may consider whether or not she feels obligated on her own to recuse herself from this case, which remains an ongoing obligation whether or not the defense is seeking her recusal. Wherefore the defense files its response to Judge Gull's May 31st, 2024 order or judgment of the court concerning her denial of the defense request for disqualification. Sincerely or respectfully submitted, Andy, Brad, and Jen. I just gave them all a little short name. Certificate of service and compliance. This is sent to all the attorneys, and that is it. You don't need to take the bed over there. The bed was fine where it was. And my dog's old age, he's decided that wherever the dog beds are, he has to move them. And now they travel around the whole house. I don't know why, and I don't know what's ever changed. He never did this before until the last couple of months. But he literally moves the entire bed wherever he wants it to go. I'm like, just lay in the bed where it was. There's no difference. There's no remaining remedy, not just a list of shit that annoys the shit out of the defense and us. Right. Innocent. See, them even ending it like this just makes me think, like, maybe this is their last, like, you know, just do the right thing, judge. Like, just go. Just go. The bed was fine. I know it was. You never know when a nap might strike. So stupid, though. Just lay in it where it was. Dog wants the bed to be comfy, too. Silly dog. I got really confused about the bed. Sorry, it was just a side note because he's like knocking into stuff as he's dragging the bed everywhere. I carry my bed with me everywhere. I carry my bed with me everywhere if I could. I had a 100-pound Great Dane. His bed was wherever he decided it is. But like he takes the dog bed. Like the dog. For how long? However long I've had this channel, I've had 2 dog beds underneath my desk always. Now the dog bed, it travels. Now it's over there. I don't know what he's doing. Your dog won't use the dog bed? Mine will just take it with. Lynn, there's no plea deal. With all that's happened, Rick is most likely guaranteed a second trial if convicted. They're definitely setting up an appellate court to take the case. I don't know if he would win. We don't know what's going to happen yet. We don't know what's going to happen yet. I know there's a lot of people who think plea. Lynn might think plea too. I don't. I just don't. I do not foresee a plea deal on either side. I don't see Nick offering a plea deal, and I don't see Richard Allen or Richard Allen's attorneys wanting to accept a plea deal. So I don't. Plea just it's bewildering to me. The only thing that when people say plea deal, the only thing I can think is that maybe they actually mean like they think Richard Allen is just going to change his plea and just like plead guilty. Because what's the plea going to be? Like, I'll charge you for one and not the other? I mean, the sentencing on one is a little bit harsher than the other. But if he's convicted on, you get the 2 kidnapping resulting in murder, felony murder charges, and then you've got the 2 murder charges. So he's like, I'll drop these 2, but you can still get those 2. You're done forever. I just don't see it. I don't see Nick wanting a plea. I think Nick thinks he's going to win. I do. I think Nick thinks he's going to win. I think the defense attorneys think they're going to win. And I think they believe that Richard Allen is innocent. Whether we believe it or not, that's up to us. But I think they believe it. There's no death versus life. There's no death. There's no death on the table. They're not changing it. They're not going to add the death penalty now. So there's just no plea. That's where I'm at with it. You think he's going to try to up it to a death sentence, and just to get him to come back down and plea? Yeah, I don't think so. I think if he was, I think he would have done that during the upping of the charges back in January when that was happening. I just don't see it. It makes no sense to me, and I don't care. People can believe that. If that's what they want to believe. I mean, one of us is right, one of us is wrong. In the end of the day, we got a 50-50 shot, even though I think it's more like an 80-20, 80 me. That's okay. I still like people whether they think the same as me or not. I witnessed the fact that the very LE who invested this case are liars. Yep. Nick's version of plea deals are so bad. I know. Capital qualified attorneys get paid a different rate. You can't pay a lower rate for a whole case and then change that. They would have already done it. So but I don't, like I said, I don't see a plea either way. And he's not going to add the death penalty to it. Oh, Yellow Jacket, appreciate you getting me through a long drive with fair coverage, kindness, and a little humor. Well, sometimes all we can do is laugh. But thank you very much for the super chat. Take it on my road trip with me. Richard says more like 99-1 in favor of UT. I just don't see it. Little Charlie tease. Oh, my Sphinx kitty uses me as a bed, and I'm okay with that. Oh, I want that kitty. He's so cute. She was dropping pictures of her kitty in the chat, and I'm like, all right, I want that one. I've always wanted a naked cat. Those Sphinx cats are so cool looking. But I want one with a bigger head. I don't want one with a tiny head. I need a bigger headed cat. The tiny head that actually is kind of scary. State's motion to amend my amended charges and also help me, Jesus, amen. Even a death sentence is the same. It's like they haven't carried it out in forever, and there's a wait list. I'm pretty sure Indiana is actually one of the ones. Were they on the list with Idaho? I'd have to go back and look. So Idaho, about a year ago, had requested to be able to maybe it was Ohio that I'm thinking of, put the firing squad back in play because of the medications not being readily available to put people to death. There was a state in the Midwest that was on the list of wanting to also do it. They weren't approved yet, but it might have been Ohio, though, because I might be thinking of Chad Dorman's case. But I think there's one of them. It was Idaho for sure. They got it. But there was other states on the list that were wanting to also do it. You guys are all like, that's Idaho. Yes, I know that's Idaho. But they got theirs passed. Was Alabama? Oh, I think it was just copying everybody. Stop doing that. Stop copying everybody. South Carolina was, Alabama. There was a list of like other states to follow that were wanting to do the same thing. The public is already aware and notified of a death sentence. I don't know what you mean by that. They're not. You'd have to actually file to go with the death penalty. We can see any state you want us to, T. Say it's Ohio. Because I think that's what it was. I thought it was Indiana at first, then I was like, wait a minute. I think it's Ohio. All right. Well, we went through all that. Freaking Delphi, man. They never cease to amaze. I don't even know. I think I used to have like a feeling on what like I thought was coming next. And I just don't. No. I just don't know I don't know what she's gonna do. She's fighting tooth and nail to just say no, I'm staying, and that's it. Too bad. Like, too bad. Definitely Ohio. Thank you, Luke. You're saying that for me. Hold on real quick. All right, that's the hubs. He made dinner, so he's telling me that dinner's ready. Yeah, she'll do what she wants. I will, like I said, I'm going to do my best. I fly out in the morning. I'm going to do my best. Hopefully, maybe, I'm shooting for maybe Sunday. I don't know. Though, and I don't want to put anything on the books and then not be able to follow through. But I'm shooting for Sunday. And hopefully we can do like a whole week recap of all the crazy in the Karen Reed case. I will try to do a live if I have somebody who would be willing. If new documents for Delphi come out, I won't have any way to share the screen. So I need somebody that could help like put the documents up. Let's see, what else is there? I arrive back home Tuesday, so I would. There's some new docs come from Madeline. I need them. You got it. Flying scares me more than anything. Google that hole in the ground in Colorado where they put the really bad ones. It's so bad. Okay. Other than that, I'm gonna wrap it up. Thank you guys for hanging out with me on. What day is today? Today's Tuesday. No, today's Tuesday. Yes, tomorrow I leave. I don't even know what date is it. I didn't even say Happy Tuesday to everybody. Happy Tuesday, you guys. All right, well, go enjoy the rest of your Tuesday. Thank you guys for being here. I appreciate each and every single one of you. I know that you guys have 1,000 other places that you could be, and yet you choose to spend your time here with me. And I can't thank you enough for that. So go. What is today? I don't even know. I don't even know what the day is anymore. Who knows what's going on in the world? Otherwise, I will try to see you guys hopefully Sunday. That's my plan. I'm going to post pictures in the members only and show you kind of our trip as we go through. So look for those too if you guys are interested in the mommy-daughter trip to Nationals gymnastics competition. All right, I'll see you guys later. Have a good one.
Do you dare to follow me down? Head into the unknown. Down the rabbit hole. Where it stops, no one